Court officer? Court officer?
ಹೇಳಿ ಮೇಡಮ್.
ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ?
ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
11:30ಗೆ ಸಿಟ್ಟಿಂಗ್.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು. ಅದೇನೆ ಇವಾಗ ಅದು ಕೋರ್ಟ್ ಮುಂದೆನೆ ಪೋಸ್ಟ್ ಆಗ್ತದೆ. ಅಲ್ಲಪ್ಪ, ಈಗ ಪಾರ್ಟಿ ನಾಟ್ ಅರೇಂಜ್ ಎಸ್ ಎ ಪಾರ್ಟಿ ಅಂತಂದ್ರೆ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆನೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ? ಹಾ, ಅಲ್ಲ, ಕೆಇಬಿ ನಮ್ಗೆ ಇರೋದು. ಕೆಇಬಿನ? ಹಾ, ಕೆಇಬಿ ನಮ್ಗೆ ಅಲ್ವಾ ಇರೋದು. ಎಕ್ಸೈಸು ಕೆಇಬಿ, ಎಂಬಿ ಎಲ್ಲ ನಮ್ಗೆ ಇರೋದು ರೋಸ್ಟ್ರು. ಅದೇನೆ ಮತ್ತೆ ನೀವು ಅದನ್ನ ಈಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ ಅವರು. ಏನೋ ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು, ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಡಿಪ್ಪ. ನೋಡಿ ನೋಡಿ ನೋಡಿ, ನಿಮ್ ಪೆನ್ನಲ್ಲೇ ಆಗುತ್ತೆ ಅನ್ನೋದಂಥದ್ದೆಲ್ಲ ಅಲ್ಲೇ ಎಂಟರ್ಟೈನ್ ಮಾಡಿ ಕಳಿಸ್ಬಿಡಿ. ಅದೇನೆ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಪ್ಲೇಸ್ ಮಾಡ್ತೀವಿ ಇನ್ನು ಅಂತ ಬಂದಿದ್ರು ಅವರು. ಅದಕ್ಕೆ ಇಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ಇರಪ್ಪ. ಹೌದಲ್ವಾ? ಮತ್ತೆ ಏನೇನು ರಿಜಿಸ್ಟ್ರಾರ್ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ ಅರೇಂಜ್ ಆಫ್ ಪಾರ್ಟೀಸ್.
All memos to the court of law.
Let's one memo, my lords. And
All memos to the court officer.
One matter, 230 minutes. Let up discussion. There are 25 students in the property.
Tomorrow. You take the memos, give it to me in the afternoon, I'll see. And any of the memos, no urgency is written on that. Please return it, keep it outside the report, so that they'll collect again.
my lords, on 29th, my lords, the matter was listed. My lords, your lordship was not sitting. My lords, again, the matter was not listed. My lords.
Why is it a special this thing for you? Write it on the paper and give it to the memo and give it to the court officer. I look at it and.
Two times I have moved, my lords, but the matter in view of urgency.
Yes. Please call the list.
List number 1.
Objection to allow the CRP. I have no objection to CRP is filed by somebody else. I have no objection to the other CRP.
Take the list it tomorrow.
Not for posting, not for posting. One matter, your lordship disposed of permitting us to construct the property limits. The order was passed on 1960.
Permitting to?
Construct the, permitting for construction of the property limits. Operative portion of the order could be released from this. The order is passed
Oh,
on
that's already over.
No,
Take that.
1960 order. Please.
I have already done it.
With this honorable court's kind leave, only one matter. Serial number 14 in the second list, there is some urgency. I had moved the matter. Your lordship had granted any ex parte order of the trial court was stayed by this court. Subsequently, on 16th, the other side said they'll take 2 days time. They have sought for a longer time. Your lordships have adjourned directing for a preemptory order against me. I was notified after 4 days. 2 days time was given. Some accommodation today, my lords. Urgency is there. 14 in the second list.
Every vacate matter, there is urgency and I can't take up. Yes.
List number 1 for orders.
Please don't make mentions.
My
Serial
lords.
number 28.
It will not reach. Yes, please
But
call the
still
list.
there is an
My lord,
urgency
please call the
serial-
list. I'm not going to
Serial
hear
number
any
7,
adjournments
please.
now.
Number 1, serial
My
number
lords,
1.
one.
Orders matter,
Here
Raju.
for the petitioner,
Yes,
For petitioner.
No,
Mukesh
the-
V. Charity for respondent.
the seventh respondent,
all these memos, send it to the chambers. Yes.
a lawyer, my lord, acting as power of attorney for the sixth.
First of all, is it the matter you're submitting the
yes,
other
my lord.
day? So first you submit, why should the court interfere?
My lord.
Will have jurisdiction under 227.
Yes, my lord, fraud played on this court, civil court, small causes court. Decrees have been obtained against orders, my lord, of this honorable court. 25,000 rupees cost was imposed upon the seventh respondent on one occasion for filing a fraudulent suit. He goes and files one more suit again my lord, I am the owner of a property in possession for the last 30 years. He creates documents as if he's a allotee under BDA. BDA files a criminal
Please,
case.
what is the order that's impugned? Let us look at it.
No, to come to that order, may I state a few facts, my lord, just a few facts. I will not take more than 2 minutes, my lord.
Yes,
My lord, I am,
yes.
this land measures about 10,000 square feet industrial land allotted to my predecessor in title, from whom I purchased the land in 1991, my lord.
Yes,
From then I have been in possession.
yes.
My lord, in 1997, the BDA files a complaint against the sixth respondent who produces fraudulent documents before it and seeks a Khata certificate. A criminal case BDA files against the sixth respondent saying that he has fabricated a sale deed, possession certificate, and letter of allotment in his favor. The same person, my lord, files a writ petition before this honorable court in Annexure E, if your lordship will kindly see page number 90. He files a writ petition saying, I have been allotted land by BDA. They are not executing Khata in my favor. Kindly direct them to execute Khata. The stand that the BDA takes before this court, on page number 90, it's only one paragraph order, my lord. Page 91.
Yes.
The claim of the petitioner for issue of Khata in respect of immovable property said to have been allotted to him by the respondent BDA, Bangalore Development Authority, is opposed, stating that such allotment was never made and therefore touches upon the merit of the claim. Dispute relates to questions of fact which cannot be ultimately adjudicated in the writ proceeding under Article 226 of the Constitution. Petitioner must stand relegated to a competent civil court. Petition rejected. This order becomes final. He then, my lord, in 2017, files a suit for injunction against me and my neighbor, claiming that we are trying to interfere with his possession of this property, which is never allotted to him.
No, what I'm not able to understand
Yes.
is how this order will come in the way of the petitioner.
But the BDA stand was, sorry, sixth respondent. BDA stand was, sixth respondent was never allotted any land by BDA. His claim that he was allotted land by BDA is incorrect.
This judgment, we cannot, this is not an order on merits.
Yes, my
We
lord.
just recorded the submission of the BDA.
Correct, my lord.
Then it relegated the petitioner to the civil
Correct.
court.
He goes to civil court, does not file any suit against BDA. He files a suit against me.
No, that we will appreciate
Yes.
later. But as far as this order is concerned, nothing has been expressed on
He-
the merits.
very
of the
well,
matter.
very well.
And even that BDA, whatever
Their stance.
that need not come in his way. Then
Very-
what happened
my
after
lord,
this?
then he files a suit
Yes.
at page number
OS number?
90, OS 4545 of 2018. He files, my lord, page number 92,
Yes.
annexure F.
Yes.
In this, he claims, I have been allotted land by BDA. Two people are trying to interfere with my possession.
For the respondents in the
My
defendants.
lord, my predecessor in title and my neighbor, who's also an allotee by BDA. Both of us are in possession from 1976.
Fair injunction, what has happened?
But that suit, he does not get an injunction order. Notice is issued. Ex parte, he doesn't get an injunction, notice is issued. What he does is he advances the case again 1 week later, court, and files one more application for injunction. Court says I cannot pass any injunction order without hearing defendants. He withdraws that suit. But the withdrawal is on page number 23/7/20 9/7/2018 at page number 100. He withdraws that suit.
Yes.
Then, my lord, on 23/7, exactly 14 days later, files another suit against the very same parties, asking for the same relief, injunction.
Yes.
He does not disclose that he had filed an earlier suit.
No, you are not a party to the proceedings.
My predecessor in title is a party.
When did you purchase the property?
I purchased the property, my lord, in 1991. My sale deed is at annexure B1, page 35.
Your predecessor in title has not filed the written statement.
He was not even served with notice in both the cases.
Anyhow, this compromise decree is not binding on you.
My lord, I have been ejected from the premises on the basis of the compromise decree by a person, my lord, who has no right to the property. My lord, when he files a second suit,
A suit for injunction, where is the question of ejectment?
suit for no, no, I will only state no, the second suit for injunction he files. In that suit, my neighbor who's made a party is served with notice. He files a CRP. He files an order 7/211 application for rejection of the plaint on the ground that he has played fraud on the court. His suit is not maintainable. The bars by res judicata because the earlier suit has been withdrawn without any liberty. This honorable court, my lord, passes an order castigating sixth respondent that he has played fraud on the court. He has not obtained permission by the earlier court to file a second suit. 25,000 rupees cost is levied upon him. Now, that's page number 130. Order in CRP. In all these proceedings, sixth respondent is represented by seventh respondent who claims to be an advocate. Maybe only two paragraphs, paragraph 2, page 130.
Yes.
This court has noticed that the plaintiff respondent herein has abused the process of the court by filing OS 4545 of 2018 before the additional city civil judge and sessions judge Bangalore for perpetual injunction and withdrawing it soon after the court issued notice on the application filed by the
No, the
plaintiff.
suit is dismissed.
25,000, para 3, 25,000 rupees cost is imposed on him. Thereafter, he continues the suit against my predecessor in title because my neighbor against him, the suit is dismissed. Against my predecessor in title, suit continues, which he withdraws. Not on 17/9/2025 at page number 132. He files a memo for withdrawal.
Yes.
On 27/9/2025, 10 days thereafter, he files a suit for ejectment against the 8th respondent, who is the neighbor of 7th respondent, power of attorney. Now that's page 133, my lord, your lordships will find. Annexure L.
Yes.
The order sheet is at page 151, if your lordship will kind.
This defendant is your vendor.
Sorry,
This defendant is your vendor.
no.
Suit for rejectment.
No.
He files a suit against.
Fictitious. That person does not exist.
Hmm.
The person against whom he filed the suit for ejectment does not exist. R8 in this writ petition. Not the
Why when he files an execution, why can't you file an objection petition in that?
Lord, execution is closed without even they come and take possession one evening. Next morning, execution is closed. Lord, the entire proceeding has gone on in 1.5 months,
Now,
in 45 days.
whatever damage to be caused is already caused.
Yes, I understand, Lord, maintainability is.
Why I am on the point is, if in this way, in all the civil proceedings, these kind of things happen day to day. It is not something very, very unusual and a different case that it has happened to your client. So in every case, if High Court starts exercising under 227, and where is now in all these cases, even the evidence might be required on some of the aspects. How can we consider?
May I make only one request, Lord?
Yes.
If the BDA is directed to file a statement, BDA has filed a statement in the earlier writ petition, the file has been destroyed.
Let whatever be, now, whatever the stand you are taking, or any of this court has to, I mean, whichever is the court dealing with the matter, has to issue notice, hear the parties, and also if something is required, evidence is required. That also has to be taken into
My
consideration.
only submission is not this.
So you can't expect
It's
this
clear as
court-
day, my Lord. Fraud is clear as day.
No, but still, there is a forum available to you to set aside this order.
And alternative remedy, I'm available. I understand, not in the case where fraud is played on the court. Not once,
What I'm
repeatedly.
saying, fraud is played day in and out in several cases by the litigants. So every fraud that is not available to 227.
226 also I have invoked your lordship jurisdiction under 226 in this writ petition. Lord, I have mentioned also because since fraud has been played on the court. Lord, 35 years I'm in possession. Overnight I'm thrown out by a person who has repeatedly lost in court where BDA says he is nobody, he's a stranger to the property. BDA has filed a criminal case against him.
Appear for whom? Huh? Notice to the respondents.
But they're all appearing before your lordships.
No, he appears with the,
R7 is the person, Lord. He's the power of attorney.
he appears with the state, chief with the BDA, then where are the other parties?
No, R7, Mr. Shivaram was
Where is
filed.
Mr. Shivaram? No representation on behalf of
R7.
land council appearing for R7. Already notices,
Yes.
R1 to R3. The BDA shall file their objections within a period of 2 weeks. Does this matter after 2 weeks? Yes,
Till number 2,
Take
2 weeks.
2 weeks. Yes.
Flash.
Do I appear for the petitioner? But the petitioner is the defendant in the suit.
Subhash,
suit for injunction. If my lords are pleased to see the prayer, is
This is
for,
IA.
please, IA was for temporary injunction allowed by the learned trial judge, confirmed by the first appellate court. Agreed by that, I am before my lords and the writ petition.
Oh,
Here,
you are
my
the
lords,
defendant in the suit.
please, my lords,
You are the defendant in the suit.
I am the defendant in suit.
The order in the MA.
Yes, the parties are siblings of the same family.
Hmm.
And now, my lords, the trial, first appellate court order is that, my lord, page number
Let's
50.
see from the reasoning part.
Yes. Facts, my lord, I can read, my lord. In this, in the affidavit annexed to the application, it is stated that the plaintiff is the absolute owner in possession of the suit item number 1 to 4 of the schedule, that is about 4 acres of land. The suit item number 1 to 2 were purchased by him under registered sale deed in the year 1989, and the suit item number 3 and 4 were purchased by him under registered sale deed in the year 1979. He was an employee in the government. So the suit scheduled properties were thereafter mutated in his name. He alone has been in possession and enjoyment of the same from the date of purchase. However, the last few years, the defendant number 1, who is his brother, has been claiming ownership over the suit schedule properties. The defendant number 1 had only been permitted to supervise the land in the absence of the plaintiff, but by misusing such trust, he is now claiming to be the owner of the suit schedule properties. The defendants having no right, title or interest over the suit schedule properties and are now interfering into the peaceful possession and enjoyment of the plaintiff over the same. They are also making efforts to dispossess the plaintiff from the suit schedule properties. They repeatedly issued threats to the life of the plaintiff and with the intention to grab his properties. Though the matter was taken to the police, no action was taken by them. The plaintiff is having prima facie case and balance of convenience rise in his favor. He would put to irreparable injury and hardship if the order of temporary injunction is not granted, etc. The defendants appeared through their counsel before the trial court and filed their objections. The defendants contend that the grandfather of the
What is the
defendant
injunction
number 1.
sought?
Now, my lords, the cause of actions to the suit arose in the year somewhere in 2020. If the plaintiff is seen, suit is filed in the year 2023. Cause of action, if there is a cause of action in the year 2020, having some set of disposition, my lord, any person would immediately rush to the court and seek a protection. Nothing is done for the period of 2 years. Thereafter, who has admittedly has delivered, it is not a case of title. There is a partition suit pending between us, filed by us, it's in the same court. It is a suit for mere injunction for which one has to establish the possession, prima facie case, and irreparable. And these are the principles. The learned trial judge has referred to certain judgments. I have no difficulty of accepting that. My lord, having spent 2 to 3 years after the cause of action alleged in the plaint, my lord, a person comes to the court and seeks an order of injunction, seeking certain immediate threat, and the wordings are very, my lord, shocking. If I can read it, the trial judge's order also, the ancient type of
This for injunction.
injunction,
The source of title is a sale deed which has been
sale
executed
deed of
by
the year 2 decades ago. Yes.
whatever it is, it's a sale deed.
Yes.
And as of now, that is no suit is filed by you seeking cancellation or
Suit is
recently
filed by me for a partition.
partition, and you have not questioned that sale deed.
The sale deed is not questioned.
So-
Sale deed is, my lord, my humble submission is that, my lord, the sale deed, I think in the partition suit pleadings, it is a bogus sale deed. A person who was employed in the government without the knowledge of the karta of the family, the grandfather,
Who will,
whatever. Now, my lord,
who will declare it without you questioning it?
that's what, my lord.
You can't keep to yourself saying that it is a bogus document. Some court has to
Partition suit
declare
is
it.
pending. Now, my lords, though the learned judge has granted the order of temporary injunction in a suit for which the alleged
What
cause
is the
of
nature of the property?
now, my lord, it's an agricultural land, my lords, 4 acres. Now, along with writ petition, my prayer, my friend press may have had some correction, sought for an order of temporary injunction in this honorable court, which may not be, my lord. What is ordered by this honorable court is, now the suit is in progress. Suit is in progress, it can be decided either way. The learned judge is free to grant an order of permanent injunction. What is ordered by this honorable court is, keep it status quo.
Why should it be?
But because now it
Two
will
courts
give
have
scope for.
concurrently held against you.
Yes.
Why should this court
It
order
will,
an
it
order
will
of
give scope
status quo?
for, again, a small extent of land fighting. Now, difficulty is that, my lords may kindly see how this can be,
Status quo is the most dangerous order without a finding.
status quo, my lord, in this land like property like this agricultural land.
In a vacant site, somebody
And-
shows
and-
that he is the
and-
owner of
and
the
my lord, a
property.
person-
What else is required?
And a person claiming possession of the, I can give my example.
No,
I
title
own-
will not follow possession.
I own large extent of agricultural land, but possession is by the person who I have allowed to be there in the land. I am away in Bangalore. So Land Reforms Act was there during those times, 79. Prohibition was there to acquire any agriculture. He says he has acquired the property by sale deed. That time there was a Land Reforms Act, section 79 bar. Any person having 20,000 and more income per month over and above agricultural income is not entitled to buy an agricultural land, even if it is a family property. One can have by succession. But in this case, my humble submission is that the perfect order of this honorable court is made to keep them status quo. And one line I will read by the learned trial judge's order. This is not, when pleadings, I understand that most of the old pleadings, this word is there. My lord may kindly see page number 88 to 38. Defendants, their henchmen, agents, gundas. My lord, agriculturist cannot afford to have engage a gunda. These are not the words to come on the court paper.
You know, that those are all not the criteria for granting or
No, no,
vacating
I'm
injunction.
submitting, this cannot come on the valuable papers of the court.
Yes.
This, I understand that 20, 30 years back, these pleadings were there. But
Anyhow, we can't, anyhow, that is the understanding of the advocate what to do.
yes, now my humble submission is that status quo, trial judge may be direct, now it is in progress, expedite the suit. And what happens is, if it is dissolved,
Will not, which year is the suit? Suit of 23 cannot be expedited.
it is my lord, evidence stage. Evidence
Will
stage.
not be
And
expedited. Will
most
not
of
be
the,
expedited.
my understanding is that, my lord, a court like this, trial judges, my lord, not so heavily loaded not to decide the cases.
But anyhow, apex court said that this court can't issue a mandamus like that.
No, expectation can
Unless and until it's such a
no,
case.
no, my lord, if
which
both
warrants
sides cooperate,
interference.
both sides cooperate. Both
You
sides,
please wait. You don't have to oppose anything when the court is saying something in your favor.
yes, if the both,
Page 18, partition suit.
partition suit, also were, when that partition suit for the same property is pending.
Then file, you have your own remedies, section
That is
10.
there.
That you avail.
If that injunction,
Not express
if
anything.
that injunction is accepted, it will have some kind of evidentiary value to him to say that the sale deed is there for me.
You have not
That
even
cannot be
questioned that sale
partitioned.
deed. You have not even questioned that, how will that sale
No,
deed
sale
come in
deed,
your way?
because the limitation is also lost.
Please
So
come.
humble submission is that, direct the status quo to be kept as it
No,
is.
no.
Trial court may kindly be directed to
No.
be.
Agreed with the order. Agreed with the order passed in. Amendment number 25 of 2025, dated 74/2026, by the senior civil judge and JMSC at Tarikere, confirming the orders passed in. IA number IA number 1 in OS number 14 of 2023, dated
The order is dated 27th of November 2025.
huh?
The trial court's order is 27 November 2025.
27 November
2025, that's the trial court. First
2025. Yes, this is not required. Order in
Oh, yes. 14 of 2023.
number, MAD order dated 17th April 2026, confirming the order passed in I number 1 in OS number so and so by the principal civil judge and JMFC Sarkare. The petitioner defendant is before this court. The respondent herein filed a suit for injunction. And in that, I number 1 is filed seeking temporary injunction restraining the defendants from interfering with the peaceful pursuit and enjoyment of the plaintiff. The trial court, by order dated 27 November 2025, has granted injunction. While granting injunction, the court has observed that the documents placed by the plaintiff indicate that he purchased the suit scheduled properties in his name as far back as 1979 and 1989. The revenue records have also stood in his name for several decades. The defendants, having remained silent for such a long period, now contend that the suit scheduled properties are the joint family properties and that fraud was committed by the plaintiff in obtaining the sale deeds. These are complicated issues requiring adjudication during trial. However, based on the document that came to in existence long ago and remained unchallenged until the filing of the suit, and which stands in the name of the plaintiff, a clear prima facie case is made out in his favor, warranting the grant of temporary injunction. The court has also observed that the defendants have filed the suit for partition and separate portion. At this stage, appears to have been filed as a counterblast to the present suit and therefore cannot stand in the way of deciding the present applications. And also observed that the other contentions raised by the defendants clearly warrant a full-fledged trial. However, denying interim relief to the plaintiff at this stage may result in serious prejudice to his rights. And accordingly, the court has granted injunction. The petitioner herein has carried the same before the appellate court by filing MA number 25 of 2025. By order dated 17th April 2026, the appellate court has confirmed the order passed by the trial court in IA number 1. While dismissing the MA, the court has taken a similar. The court has observed that the court has taken the same stand as taken by the trial court, and also observed that the plaintiff has produced huge number of documents, including the sale deeds and revenue documents, and could establish a prima facie case. And if injunction is not granted, irreparable loss would be caused to the petitioner, to the plaintiff, and the balance of convenience lies in his favor, and accordingly granted injunction. Accordingly, dismissed the MA filed by the defendant. Agreed thereby, the defendant is before this court. Lena senior counsel representing the counsel for the petitioner submits that an order of status quo is granted by a coordinate bench of this court on
which case?
12th of May.
On 12th of May, it is submitted that in the light of the said order, as the suit is pending disposal of the suit, there may be a direction to the parties to maintain status quo. It is submitted that the petitioner, that the sale deed that is brought into existence is a bogus document, a fictitious document. Further, in the pleadings, when he speak about the interference and the cause of action in the year 2020, he kept quiet till 2023 without questioning without initiating any proceedings. And on those pleadings, he is not entitled for any relief. It is submitted that the defendant owns vast extent of land. Further, the plaintiff has failed to prove prima facie case, balance of convenience, and irreparable loss. In those circumstances, he is not entitled for any relief. He is not entitled for any injunction as prayed for. However, both the courts have failed to consider this aspect and granted injunction. It is submitted that a suit for partition is filed, and this injunction would cause a lot of the injunction that's granted would cause a lot of prejudice to the plaintiff, to the defendants in the other suit, and all these aspects were not considered by the courts below. Hence, the order impugned needs to be set aside. Next part. When counsel appearing for the respondent, plaintiff submits that both the courts have considered the case of the plaintiff, and as he could substantiate his case by way of voluminous documents,
Number 12.
the court has rightly
Is number
granted
2.
injunction, and there are no grounds to interfere. Next part. However, the counsels on either side peruse the material on record. The suit is for bare injunction, and the plaintiff seeks, it is a case of the plaintiff that he has purchased the property by way back in the year 1979 and 1989. It is also an undisputed fact that the suit scheduled property is an agriculture land. The revenue records are in the name of the plaintiff. It is the only contention that is taken by the defendants is that this document has been brought into existence by fraud, and all these aspects have to be established by way of a full-fledged trial. As far as granting an ad interim injunction is concerned, in the light of the documents that are placed before the court has rightly held that there is a prima facie case, and if injunction is not granted in favor of the plaintiff, that would cause lot of prejudice to him, and there is balance of convenience in favor of the plaintiff. There is no explanation forthcoming from the defendants why they have not questioned a bogus document of the years 1979 and 1989. In these circumstances, both the courts have rightly held that, before that, when senior counsel submits that the order of status quo as granted by this court shall be continued during the pendency of the suit. This court is not able to appreciate the said submission. An order of status quo without there being a finding with regard to who is in possession of the property is a more dangerous order than granting injunction. In those circumstances, in the considered opinion of this court, both the courts have rightly granted injunction in favor of the petitioner, in favor of the plaintiff, respondent herein, and this court finds no reasons to interfere. Accordingly, this court is passing the following order. The writ petition is dismissed. None of the observations made by this court shall be construed as an expression of this court, and they're made for the purpose of considering the application before the court, and the court shall proceed in accordance with law. Please.
Cell number 3, Mahesh HG for petitioner. Cell number 3.
Submission got tentative date in Supreme Court is on 17/7.
17/7.
Next week is probably subsequent to that.
No grievance in that. What I bought my lord's notice last occasion. This is a suit for ejectment, and that is a suit for specific performance filed by the defendants against the plaintiff.
But is this the case? Last time you were saying that what was the submission on the last occasion about the Supreme Court case?
Supreme Court case, now the leave has been granted by the Supreme Court.
Ah.
It was listed before the Honorable Chief Justice. The leave was granted by the Honorable.
No stay order has been granted.
No, I'm not. Last time
And
we
they have
submitted.
withdrawn their application also.
No.
So they have filed an early hearing application.
We can hear these matters on the merits of it then. If there is no stay by the Supreme Court.
No, stay is not regarding this matter. It's only regarding the specific performance.
Then why can't we hear this matter?
No, I didn't say. They mentioned about the Supreme Court matter.
Why are you
coming up.
mentioning about the Supreme Court order?
No, my lords.
Milord, they cannot squat on the property without paying the rents.
No. If Supreme Court case has nothing to do with this,
Yes.
let's not go into that. Please argue this matter and
Yes.
we'll pass orders.
Yes.
Yes.
May I please?
Yes.
In fact, last occasion they expressed
Yes.
urgency. So my lord has granted a short date today itself for
Yes.
arguments. For the convenience of the court, I will.
Take those.
Are not required.
I may be permitted to file my statement of objections on IA, my lords.
It will be disposed on merits.
Formally, my lords.
The court
Formally.
is ready to hear on merits itself.
The objections, IA
Objections on
objections,
IA, my lords, not on CRP. IA, they have.
whatever it is basing on the material
Please,
on
ma'am,
record.
please,
Why
please.
objections are required? Yes.
I would,
Which one, 216 or 216?
216, my lord.
Yes. This is arising out of which order?
This is arising out of SC 802 of 22. No, I'd like to bring to my lord's kind notice the brief facts leading to this particular case. The
I will take it up at 2:30 if it takes time because I have to complete the list.
Yes.
2:30. Yes, next.
2:30, it's bit inconvenient for me. There are so many matters.
But I have to, if he's seeking stay, I have to hear him.
Tomorrow,
however it's convenient to the court, I will
Tomorrow.
cooperate.
please.
Tomorrow, this
2:30.
matter tomorrow at 2:30. Again,
2:30.
morning it takes time. Yes, 4.
Cell number 4, preliminary hearing Srinivas for petitioner.
But I prefer petitioner in this case. But it was a Friday's matter, my lord. My lord, my friend made a submission. I was online, I was not let in, my lord, on that day. I'm sorry for that. Now, my lord, he says it is disconnected. My client's instructions today morning, my lord, it is not disconnected.
How can it be?
I will, my lord, he says,
Take that.
and my client's instructions are, my lord, they came to the property and they have given them some time and thereafter they went back. It is not disconnected, my
I'm
lord.
hereby submitting the report that the RR number installation has been disconnected on 2/7/2026. Meter details mentioned below.
According to my client's, my lord, today morning at 8:30, I took instructions deliberately because he made a submission, they may disconnect on Saturday and Sunday. I was, Friday also, I telephonically took instructions.
We can't deny this. You have to, if at all, then you have to place something on record.
My lord, I cannot place negative evidence, my lord. I cannot place any negative
that's
evidence.
right.
I can understand that.
So
My
because
lord,
when they say it is disconnected, then you seek for restoration of
my
power
lord, your
supply.
lordship may modify and pass interim order restorating, my lord, the interim order, what
Why
I
should we do it?
my lord, interim order, the coordinate
Disconnected,
bench
you
have
modify-
granted the same relief.
No.
Yeah, coordinate bench have directed, that is the certificate, what I am relying upon, once judge, one interim order, what I am relying upon, it directs to restore the connection.
How many interim orders, how many writ petitions are warranted? What is the, why you are
My
questioning
lord,
that
my
order?
property is measuring 50/40. I have put up
So
construction.
please come to your prayer. Why the power supply should not be disconnected, according to you?
Blood, in this,
Issue a writ or so and so.
yes, my
Why should we interfere with the notice? 27/5/2026 notice. Why are you questioning in the month of July?
my lord, it was never served upon me on 27/5/2026.
When was it served on you?
My lord, it was served about 3 days back before the filing of the writ petition, about 3 days back. That's all, my lord.
How you received the notice? What did
My
you
lord,
say in your
my
affidavit?
lord, he has came and personally served upon
Let
us.
us hear, let us see from your.
My lord, that I have not clearly stated.
Then
My lord, I
without
would
saying
agree.
it, just like that, whenever the notice is given, coming to the High Court passing an order, you please restore the power supply.
My lord-
That will not serve the purpose.
My lord, your lordship may kindly see one notification passed by BESCOM itself. If the property measures 2,400 square feet, page number 42, it is in Kannada, my friend can read it and he can confirm whatever I make submission. It exempts from occupancy certificates. From, Lord, if they have a connection, it is dated 22/6/2026. Even as per that also, my lord, I am exempted from giving any occupancy certificate.
Why occupancy certificate is not required?
My lord, BBMP exempts occupancy certificate for a property measuring less than 4,000 square feet. That is 5/1/2026 notification. So it is all interconnected, my lord. And BBMP exempts, BESCOM also exempted. Now, my lord, in fact, my lord, the notice says,
Occupancy certificate is required any premises above 4,000.
yes, my lord, it is only.
Below 4,000, you can construct any like whatever you want. You don't require occupancy certificate.
It's not like
What is that law?
5 and
I understand occupancy certificate is not required for small.
30/40, my lord, up to 2,400 square feet, my lord, even there also it is the same law where it is exempted, 2,400 square feet. And thereafter, my lord, even in BBMP, my lord, as per the new amended bylaws, setbacks have also been reduced. 0.8 meter one side, 0.9 meter on the front side, back side nothing, and one side nothing. So that is the new bylaw. So following that bylaw, my lord, they have
So
Biscom also.
all this will happen provided you submit your explanation.
My
Not
lord,
coming to the High Court.
I can submit, my lord, provided if they doesn't, my lord, they only threaten disconnect, they didn't take my reply. If they take my reply, and thereafter, my lord, BBMP
They have
have not,
disconnected
my lord,
according to them.
BBMP have so far, my lord, have not issued any notice to me.
Submit your explanation or a reply to that show cause notice. I'll ask them to pass orders immediately.
Till then, let them not precipitate, my lord, because now they have, my lord,
Status quo. According to you.
yes, my lord, as on
that's it.
today, status quo as on today.
I'll record the contention and say status quo.
Yes, my lord, my
Respect to
client says
contentions.
that
According to you,
it
it
is
is
not
not
dis-
disconnected. According to him, it is disconnected. Whatever it is, let it be status quo.
yes, my lord.
Please come. The petitioner is before this court, questioning an order, notice dated 27/5/2026. It is a submission of the land council for the petitioner that for an extent of less than 4,000 occupancy certificate is not
Yes, my lord,
required.
I'll with liberty to file a fresh writ petition.
That is better. That is what I told your, the other day, your colleague also. The petition is dismissed or withdrawn with the liberty to file a fresh petition.
writ petition.
Yes.
Much. Deeply appreciated.
Bill number 5, part matter MS Prashant for HS Prashant.
Yes, where is the tie?
I'm filing.
Take
Yesterday I
that.
received details.
Yes, have you informed?
I informed my lord, in fact, it can be application. Lord, I instructed my officer to inform the, my lord.
Is it, what are your instructions? Take that.
I think
What are your instructions? Has he informed or not?
must be, I think, orally informed.
No, by this time you should get instructions. There is no must be. I have to record the reasons whether it is done or not.
By mail. Informed by mail or by email.
Land counsel for the petitioner submits that as per the orders passed by this court, the IA is filed. What is this? To implead the auction purchaser as a proposed respondent number 3. The notice to respondent number 3. Land counsel appearing for the respondent bank submits that as directed by this court, they have already informed the same to the auction purchaser about the fact that the matter is coming up on Monday. List this matter on Wednesday. You serve them this through the bank.
Let them, my lord, no difficulty, my lord. If they'll approach, I'll serve a copy to them. It's not. Lord, I'll say only one thing.
I am taking it up on Wednesday. Please don't start everything. Wednesday in the same place it will come. The bank shall serve the petitioner through the bank shall serve all the documents of the writ petition on the auction purchaser. List this matter on Wednesday.
One more
As
thing.
already indicated by this court, by Wednesday, if the DD of 12 crores is not placed before the court will not go into any other aspects and the writ petition will be dismissed, relegating the parties to avail the appropriate remedies.
One more indulgence. One application for amendment is filed, bringing, my lord, all these new facts into record, my lord. That may kindly be allowed. I'll file an amended writ petition tomorrow itself, my lord.
What is whatever you want, you can,
That is already on.
the petitioner has also filed what do you call that?
Application for amendment,
Has filed an application for amending the pleadings.
please.
And
Pleadings and the-
amended pleadings, IA is allowed. And amended pleadings are taken on record. And the petitioner shall carry out the necessary amendments, both in respect of IA number.
IA number 2.
What is that pleading application? IA number 4.
2 of 26.
2 of 26.
2.
Yes.
I'll
This
be
is
filing-
matter Wednesday, same on the top of the list.
Please.
Interim order earlier granted is extended. I'm telling on Wednesday, no more argument.
I
If you
understand.
come with 12 crores DD, then we'll hear the
Auction purchaser and
auction
some solution
purchaser
can
and
be,
the bank.
if he's agreeable, great.
And that day, I would like you to place the judgment which is passed by me. You
I'll
place
place
it on record.
I'll
on
place
that.
it. Great.
Yes.
Please. Great.
Bill number 6. Bill number 6.
Lord, counsel for the petitioner in this case, my lords. My lords, they had filed an OS in the lower court, my lords, where I had filed the WS written statement in which In written statement, para number 7, page number 20, my lords.
You filed an IE under order 6 rule 17.
Yes,
You are
my
the
lords, for
defendant in the
amendment. Yes, my lords.
You are the defendant in the suit.
Yes, my lords.
Where is your application?
Application is on page number 22, my lords. The single alphabet no wasn't added in the paragraph number
Is of the
7.
year 2017.
Yes, my lords.
When did you file this? What is the date of affidavit? It is on 23/8/2025. What is the stage of the suit?
My lords, as per now, the judgment has been done and they have gone for a regular appeal, my lords, in that, in the session courts, my lords, hence filing this memo for the amendment of,
That you have to say first that
Yes,
this
my lords.
petition has become infructuous. Take that.
Yes.
The memo is filed stating that during the pendency of this writ petition, the suit is decreed.
Yes, my lords.
Decreed or dismissed?
Decreed, my lord.
Suit is decreed and against that appeal is filed. Hence this writ petition has become infructuous. Hence he wants to withdraw the writ petition with the liberty to raise all the contentions before the appellate court, accordingly dismissed as withdrawn, keeping it open to the parties to raise all the grounds before the appellate court. Yes,
Cell number 7, Vinay N for petitioner.
Much obliged.
yes. Batch matter.
No, my lord, it's a separate matter. Interestingly, my lord, what happened was,
Who appears for the respondents? I'll hear them and pass orders. Who appears for the respondent?
respondent number
counsel?
1, my lord, is, yes, I think Mr. Prakash appears,
1 minute. Where is the cause title? Page number?
page 6.
Karnataka Electricity Regulatory Commission?
Yes, Mr.
Who-
Prakash,
Prakash. And for the two?
not, there, my lord, he had appeared in person before the KERC.
Mangalore Special Economic Zone?
Yes.
So office at Mangalore Special Economic. One person is fine. Your
The
name,
other,
questioning
other
the order
matter,
of the
not somebody else, there's another matter, there not somebody else is appearing, but I don't know whether they'll appear in this.
What we'll do is we'll print their name. If they come, it's fine. Or else also we'll hear the regulatory commission. So Mr. Prakash is directed to take notice on behalf of the respondent. And for the second respondent, it is submitted that in connected matters,
But it is not a connected matter.
in
It is
another
this-
matter,
In another
for
matter.
this Mangalore, for the second respondent, who appeared,
Correct, Lord.
tell the court officer.
Yes, but I
So and so has appeared. Registry is directed to print the name of so and so for the second respondent. For the first respondent, Mr. Prakash, then counsel the petition is petition should show the copy of the writ petition on the counsel appearing for the first respondent. When do you want?
not, after 10 days, my lord,
This is matter on,
4th of August,
yes, 4th of August.
please.
Cell number
Same state, my lord.
8,
Yes,
cell number 8.
in preliminary hearing. You see,
I've been instructed to take notice for BESCOM, my lords. My lordships could direct him to give me a petition copy.
It has been furnished twice.
this matter has come up.
In fact,
so
it has been
on
served.
Excuse me.
It has been served on them.
Yes.
A copy has been served on them.
Sami, I will take.
This is the second time.
I'm making it sure that in all the matters,
Yes, yes.
the panel counsels are served, but you can't take time and again. This matter has come up so many occasions. Earlier also it has come. I'll pass over, you have to, 2:30 I will take the papers from him.
I
and
will.
get instruct-
I will.
get telephonic instruction.
Milad, I have served a copy on the council.
No, it's getting, you want an order, isn't it?
No, he said on Monday, last week, that he wanted to take.
2:30, not with all other matters. I will take it up at 2:30. He will come up with instructions.
I will.
Call this matter at 2:30. Court
I will.
officer.
Cell 9.
Yes, next.
9, Rahul S. Reddy for petitioner.
Yes.
Marat, seeking an adjournment in the matter, Marat.
This is
Senior-
matter in the month of September, yes, 10.
Great.
Cell number 10, Nagabhushan
Yes.
R for petitioner.
Adding to temporary injunction was refused, my lords. The suit is one for injunction and easement rights, my lords.
Which court is this?
Lords, it is rural Hiriyur court, my lords. Hiriyur.
If temporary injunction is refused, you can go, you file writ petition.
My lords, because I have produced the entire title documents, my lords. Even easementary rights was granted to me, my lords.
Appeal can't be filed.
No, my lords, against writ and interim order, my lords. It was refused.
Where is that order?
My lords, kindly. Page number 20 to 25, my lords. Twenty-two, my lords.
What is the suit for?
My lords, suit for injunction and easementary rights, my lords, for declaration of easementary rights.
And what is the injunction sought?
Lords, I have sought for right of way, my lords.
That is the final prayer you are seeking.
Lords, final prayer is for declaration of easementary rights and permanent injunction.
And what is the material placed before the court to show that you are exercising the easement?
Please, my lords. I have produced my sale deed, my lords. at page
Perusal of
number-
the IA along with affidavit so and so. At this stage, this court has to look into only the facts and material placed on record.
However, I have been granted injunction in respect of easement
Court at
rights,
this
my lords.
time, the opinion, the plaintiff at this stage has not made it a prima facie grant. Let's look at your affidavit.
Lords,
Affidavit in
Please.
support of IA.
page number. Page number 87.
80?
7 minutes.
Hmm. Hmm. Something is wrong with the page 80.
88. 88. No.
After 84, some 42, 103, 104, 106. Nice. Some 10 pages are missing in between.
I think there is some.
Huh? Give it to him, let him show. What is the page number?
88. Para number 3 and 4, my lords. Please, my lords.
What is
Lords,
what are
kind-
the documents?
See, my lords.
What are the documents?
My lords, that is a sale deed, my lords, which has been purchased in my father's name.
Which year?
Lords, in the year 2010.
Where is the document?
It is at page number 34, my lords.
Yes. When was this rejection order?
Lords, injunction order was passed on 23/4, my lords.
What is-
Thereafter, no, my lords. Thereafter, I have filed writ petition immediately, my lords, but it was not listed.
That's why anyhow this 3-4 months time is there. You take the hand summons on the council.
Lords,
FID.
one submission, my lords. Let's kindly come to the impugned order, my lords. The honorable trial court has given me the right of way, but it has refused me to enjoy my property itself. At least I will maintain status quo in respect of my property because they are continuously interfering, my lords. If some order is not there, my lords, they will completely dispossess me
Come to
from
your
the property.
plane.
Please, my lords.
Come to the plane.
plaint at page number 70.
If once the respondent appears before the court, within a week, you take notice to them, I'll hear both of you and pass orders.
True, my lords, I admit, my lords,
You
but
have
at least.
no, without an order from the last 3 months, everything is going on well.
No, my lords, they are trying to dispose me. Now I have
They have
complained
not
all the.
dispossessed you.
My lords, they are trying because, my lords, the prices have got escalated, my lords. Even now, they are not even permitting me to enjoy my own property, my lords, because the easement right of way is granted. Even if I go to my property, they are not even permitting, my lords. It is agricultural land. Even they are not permitting me to enjoy my own property. At least.
You're not telling me one good reason why.
Please, my lord.
1 week you can't wait after waiting for 4 months. I'll take it up after a week.
One submission, my lords. I'll maintain status quo. At least in respect.
I will not grant those kind of orders without even understanding the facts of the case. List this matter on 27th, provided the petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. If the memo is filed by 24th, list this matter on 27 July in the first list.
Great.
I am for the petitioner, my lord.
Yes.
Petitioner is a defendant number 6 before the trial court. And plaintiff, that is respondent number 1 to 6 have instituted the suit for partition, my lords. Consequently, there are 2 residential houses were there. They were left out in the.
What is IA?
IA under order 6 rule 17 amendment of the written statement. And in
Where is
page
that
number
application?
53, my lords, annexure F. Allowed as.
Page number?
53, my lords. In annexure F.
Yes, let's see the affidavit.
Proposed amendment 15, incorporation of paragraph.
We'll read the affidavit.
Yes, affidavit. Yes, ma'am. I filed the written statement in this case by contending that suit schedule item 2-3 properties, which is originally assessed in one survey number, was purchased by my father by his own funds and claimed that as his self-acquired property. At the time of filing of my defense, my inadvertence and by mistake had not pleaded the source of income he got acquired the said property. Therefore, clarify this fact, I intended to give the source of income.
What is the stage of this application?
Stage, my lord, now it is posted for the final argument. But trial court has specifically stated that in paragraph page 25 in the impugned order, my lords. Kindly please.
What were you doing till this pageant?
The 2 houses are left out in that premises.
Part of original pleadings, it was there. When did you file after the trial is completed?
No, trial is completed and he has subsequently due diligence. He was not incorporated. The contention is not taken in the written statement. The only contention, my lord. Incorporation of the properties are very much necessary, but that contention is not taken in the written statement, unfortunately. And inverted ends, it is not mentioned, and due diligence, that's what the affidavit is stating. But trial court has.
After the trial, you invent.
Yes, I agree. But trial court, my lords, in page number 25, my lord. Kindly peruse the impugned order in paragraph 9, my lord has. However, though the present application will not alter the entire nature of the suit itself, but clearly shows that there is a completion of the both sides evidence when it is posted for defense side argument in order to rectify the mistake of lacuna erupted during the examination. Parties instant application file. Just clarify.
First of all, if you want stay, I'll grant stay on some costs.
Yes, madam.
10,000 to be paid to the respondent.
5,000.
Please come. The
take up 5,000. It's a old matter and it's in the remote area. The parties are
agreed with the order passed by the court dated 15th December 2025, whereby the court has refused to rejected an application filed under order 6 rule 17 and counsel for the petitioner submits is a suit for partition, and due to inadvertence, certain facts were not pleaded and they are very much crucial to the facts of the case. The court, having observed that this would not change the cause of action, only on the ground that the same is filed at a validated stage, has dismissed the application, considering the submission of the counsel and also considering the fact that this is filed at a belated stage. This court, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall pay an amount of rupees 10,000 towards costs to the respondents. Next para. The petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 28th of July or else a stay granted with this court's transfer case.
Number 12,
My lord, where respondent comes, applies. Great.
Archana Murthy.
Appearing to the petitioner, your lordships. Lordships, we are defendant number 528 in the trial court.
Hmm.
It's on IA number 11. It was not filed within 120 days. There was some negotiation talks going on, so the IA written statement.
What was the delay now?
It was a delay of 4 months, your lordships, in filing the written statement.
No. After 120 days, another 120 days.
Yes, there were some settlement talks going on.
Is it a commercial suit or a regular suit?
Regular suit.
Huh?
Regular suit.
Then counsel for the petitioner submits that the only on the ground of delay, because the written statement is filed beyond 120 days, the court has failed to take the written statement on record. He relied on a order passed by a coordinate bench of this court where the amended proviso to the CPC as dated so and so, the operation of the same is state. Considering the submission, there shall be stay of all further proceeding. Pursuant to the order.
Dispensation of notice for respondent 2-2.
Pursuant to the order dated so and so. Next, the memo is filed seeking dispensation of notice to respondent.
2-13.
2-13. Issue notice to one. In addition, petition is permitted to take out hand summon and he shall file a memo to that effect by 28th of July.
11
or
to
else
13.
First you appear.
11 to 13 is government, my lord. I'll take note.
Why to dispense with the?
Suit also, you're a formal party.
Oh, no.
There's
Then
no
if he
relief
doesn't
against.
want to give notice to you, be happy with that. The respondent petition is permitted to take out hand summon and the counsel appearing for the first respondent and shall file a memo to that effect by 28th of July or else a stay granted by this court's transfer vacated. Yes, 13.
Item number 13, Kumar ND.
I filed application seeking to appoint a translator, my lord.
Appointed translator.
Translator, my lord, which came to be rejected. There is a suit for injunction, my lord. The stage is at Further Chief of Defendant DW1, my lord. Now, my lord, the court held that, my lord, that orders findings at Paranam.
Why translator is required?
Lord, he does not know Kannada, my lord. He knows Telugu and Urdu, my lord. He needs some translator to understand the questions, my lord. For that purpose, my lord, we have filed application before the trial court, my lord.
Let's see the order. Let's see the order.
Findings at Paranam, page number 13, my lord.
13.
13, my lord.
Yes. Let's read the order, small order.
Yes, ma'am.
12, page 12 we'll read.
Yes, my lord. Page number 12, the findings at page number 13, my lord, second para. It is to be seen that DW1 has tried to permit him to engage a translator in order to assist him during the trial and cross-examination. It is to be seen that the matter is of the year 2017 and till now the defendant has not raised this issue, and now out of nowhere he has filed application, present application in order to
How
appoint.
did he give his evidence initially
My
as
lord.
DW1?
In the, my lord, in the chief examination, we have given in the written, my lord, affidavit. Sorry, in the chief examination, my lord, affidavit, my lord.
Oh, that's, he's speaking about the affidavit.
This is the only delaying
Says it is set down for further cross-examination.
further process. Earlier, my lord, in the last date of vacation, my lord, what happened, my lord, he could not able to understand the questions, my lord. For that reason, my lord, the matter got urgent, my lord. Subsequently, my lord, the thing was happened, my lord. The findings is that, my lord, this is only a delaying tactics employed by the defendant and advocates, being the officers of the court and also the staff of this court are well equipped to translate whatever the deposition of DW1 deposes. Further, the language alleged to be spoken by him is widespread, and advocates who are the court officers and also the court staff are all very well versed and capable of helping the court to record the deposition if needed be by helping in the translation. There is no need to appoint a separate translator. It will be only prolong and delay the disposal of the suit. In the court is of the view that present application
Court says court for
for recording
the court
purpose, my lord, court have given a findings, my lord.
Come, then counsel for the petitioner submits that. An application is filed seeking to appoint the translator as the defendant DW1 doesn't know, he doesn't understand the Kannada language. As such, he is not able to understand the questions put forth in the cross-examination. The court has dismissed the same, observing that there is so many advocates and officers of the court who will translate, helping the court to record depositions. Hence, there is no requirement of helping in translation. When counsel submits that, it is not the court who requires help, it is for the defendant who requires a translator to understand the questions. And this aspect was not appreciated by the court. Considering the same, there shall be stay of all further proceedings pursuant to so and so same notice, hand summons. In addition, hand summons memo shall be filed by 28th or else stay granted by this court stands vacated. Yes, 14.
14, Lokesh D.
Yes.
I'm aggrieved by the order of the Honorable Trial Court minutes, wherein they have decided IA number 5 and 6 jointly minutes. Minutes, the counsel for the defendant number 3 has filed the application under Order 1, Rule 10, 2, and Order Rule 6 of Rule 16 minutes. Minutes, the defendant has sought for the removal of defendant number 14, which is a company minutes. Minutes, this company minutes, I need to give a small background of this company. So this company is a family-run business minutes that deals with aluminium frames and aluminium products in general. So this company was started by the father of the plaintiff minutes. The person.
Please come to the order.
It's at page number 13 minutes. Annexure A.
Who are you?
I am the plaintiff minutes. I am the first wife and the daughter of the.
What is the suit for?
Suit is for partition minutes.
Come to the order, page number?
Page number 13 minutes.
1-3.
Yes. That's my only grievance is that, Milods, it is a very nascent stage, Milods, to remove the company from the party as a party from the suit, Milods.
Let's complete reading.
Please.
It is contended that the defendant number 14 company is non-existing and struck and 17/7/27 from the registrar of companies.
Please, Milods.
It is a non-existing entity.
Milods, as of now, it is a non-existing entity, Milods.
As of 2017 itself.
Yes, Milods.
It is filed when 2019.
Yes, Milods.
Then
Milods,
what will you do with
it is
that?
pertinent to note that, Milods, the father died in 2008, Milods. So my cause of action accrued after 2008, Milods, to seek a partition. Milods, there's a judgment to that effect, Milods.
No, forget about that.
Yes.
A company, which is, who will represent the company?
The directors, Milods, the members of the company.
Company is not there in existence. Who will represent?
Milods, I agree, Milods, but there are certain liabilities which are supposed to be cleared out by the companies.
By a non-existing company.
Milods, see, Milods, since I am the daughter and the wife of the father of the company, who is the founder of the company, Milods, I exist as a shareholder as well. So the company is liable to clear out all the liabilities and give out my shares as well, Milods, before ceasing to exist. I'm only reiterating the section 250 of the Companies Act, Milods. The defendants are using the company as a front to act behind my back, my lords. They've disposed of the property also.
Notice to the respondent.
Cell number 15.
That's interim order of stay, my lords.
Rupesh Kumar.
Yes, petition is permitted to take out hand summons on the council appearing with the response. We shall file a memo to that effect. Yes.
Cell number 15. Rupesh Kumar S.
The petitioner, my lord.
Yes.
In this case, the parties, the respondent and the petitioner are brothers, my lord. The petitioner, my lord, filed a civil suit for partition and separate possession, my lord, on 2/9/2022, my lord. The respondent, my lord, on 16/1/2023, filed the written statement, my lord. However, on 22/8/2022, my lord, a P&SC petition, my lord, came to be filed by the respondent, my lord. He never makes me as party to that petition, my lord.
22/8
22/8/2022, my lord. Even
files a P&SC.
P&SC petition, my lord, 45/2022, my lord, based on a will, my lord, which was executed by her late mother, my lord, in his favor.
Who is the
Alleged to be, my lord.
your mother?
Yes, my lord. They both are brothers, my lord.
Oh.
Lord, subsequently, my lord, he obtains an order, my lord, on 25/3/2023, my lord, in P&SC. And the petitioner, my lord, files an MFA petition before this court challenging the ex parte order, my lord. This court, my lord, reserves liberty to file a petition, my lord, miscellaneous petition, my lord, before the trial court to set aside the ex parte order, my lord. And accordingly, miscellaneous petition was filed, my lord. My lord, in the said miscellaneous petition, the respondent, my lord, files an application for staying the original suit, my lord, which is a previously instituted suit, my lord. Now, my lord, kindly see the page number, my lord, at 90, my lord.
90.
90, yes, ma'am. IA2 has been filed by the respondent under.
Before the court questioning miscellaneous order.
Yes, ma'am. During the pendency of the miscellaneous petition, my lord,
No.
the respondent files an application.
Now you are questioning a miscellaneous order.
Yes, my lord. After the miscellaneous petition came to be restored, my lord, similar applications came to be filed, my lord, by the respondent. And the trial court, my lord, on the same judgment, my lord, previously dismissed the application, my lord, and subsequently allows the said application, my lord. Kindly see page number 107.
Is at page number 108.
Yes, my lord. Kindly see page number 107, my lord.
No, that I will see.
Yes.
No, by virtue of this order.
Yes,
I number 1 filed with the petitioner under section 5 is allowed.
Yes, ma'am.
I number 5 filed by the respondent under section 151 CPC hereby dismissed. What is this I number 2?
IA number 2 is same application, my lord.
Delay condoned and main application is dismissed.
Main application is allowed, my lord. My lord, during the pendency of this miscellaneous petition is for.
I'm asking what is this IA number 2, IA number 3?
IA number 2 is, my lord, for staying of the original suit, my lord.
That is dismissed.
That is dismissed, my lord.
IA number 3.
And after restoration, my lord, the respondent files another similar application, my lord. And that comes to be allowed, my lord. But it is at page number.
That is why I asked you what is the order that is now questioned.
Same order, my lord. It is page number 122, my lord.
One
operative portion is at page number 123, my lord. IA number 4 filed under section 151 of CPC by the respondent is hereby allowed. Consequently, OS number 1141 of 2022, pending on the file of so and so, is hereby stayed until further order. Lord, previously that order, the very same application, my lord, came to be dismissed.
That's IA number?
That is IA number 2, my lord. Kindly see page number 107, my lord.
Yes.
Page number 107, my lord. Para 26, my lord. Therefore, in this case, I'll read. It starts from para 25, my lord.
Yes, it says proceedings of the case which are not maintainable. That's
Yes,
all.
yes, my lord.
Now, please come to this order.
Page number, which order?
Present order will read.
Yes, ma'am. Lord, relying upon the very same judgment, my lord, this IA order is passed, my lord. Even on the previous occasion, my lord, the trial court relies on the very same judgment, my lord, and dismisses the application. In the present order, my lord.
I understand.
Yes,
I said we'll read the order.
Yes, ma'am. Admittedly, OS number 1141/2022 is pending between the parties for the relief of partition and while disposing IA number 2, this court has relied upon so and so judgment, wherein the Honorable High Court has discussed elaborately that fate of the partition suit depends upon the probate of will,
in the above judgment by holding the decision of the will have direct impact on the suit. The decision is partition suit would also operate as res judicata in the probate proceedings. In such contingency, when both the proceedings are pending, the suit for partition shall remain state till disposal of the probate proceedings. Therefore, without discussing much, I opine that in order to avoid multiplicity of proceedings and the fact that fate of the partition suit depends upon probate of the will, I opine that argument advanced by
Petitioner submits that the petitioner is a plaintiff who has filed the suit for partition, and the defendant, who is his brother, has filed a P&SC without making him a party. When an ex parte order is passed, he has filed an MFA before this court, and with the liberty given in the MFA, he has filed the miscellaneous petition. It is submitted that that miscellaneous petition came to be allowed, and in that the IA number 2 is filed by the plaintiff in the P&SC, petition in the P&SC, seeking stay of all further proceedings in the partition suit that came to be dismissed by order dated 15th September 2025. It is submitted that thereafter, with the similar grounds, IA number 4 is filed under section 151 CPC. The court, having earlier refused to stay the proceedings, now without any basis has simply allowed the application contrary to the findings, contrary to the order passed earlier considering the same. There shall be the order dated so and so is there shall be stay of all further proceedings pursuant to this order.
Yes.
So that the order, there shall be operation stay, there shall be stay of operation of the order dated, order impugned dated so and so. Same person, the petition is permitted take out hand summons. Same memo shall be filed by 28th, or else is taken until the discourse transfer.
Number 16.
Grateful.
Kathleen Holmes for petitioner.
Hello, this is a plaintiff's writ petition challenging an application being rejected seeking substituted service via email.
Via?
Email. From 24, my lord, the suit's been instituted. We have been taking out process to the address in the plaint. 21/8/20.
First furnish the email.
Aye, my lord.
Then
I have filed an affidavit showing emails between the plaintiff and the defendant 1 year prior to the institution of the suit.
so how will the court know whether the same email, whether he is using?
Because, my lord, after granting of 39(1) and 2, as the advocate, we have issued an email under 39(3) compliance. That has also been replied to. And
You have shown.
I have shown, my lord, it is produced with the application. Secondly, my lord, the High Court notification which permits me to take out summons via email has 3 conditions. One, that it's on affidavit. There are emails prior to the filing of the suit. I have put it
When was
on,
that?
my lord.
When was the earlier email?
The earlier email was as the day interim order was granted, my lord, 2024.
Then why the court has dismissed?
My lord, the court has summarily rejected it the day we filed it.
Let's,
Annexure A, page number 30.
page number?
30. On a daily order, my lord, my application has been rejected.
Case advanced, where did you get that? 30?
Page number 30, correct order, my lord. Case advanced to today's board at the request of counsel for the plaintiff, who filed application under 151 CPC praying to issue suit summons to defendant by way of email. But the order sheet reveals RPD issued to defendant returned unserved as insufficient address, want of deficient process fee. Under these circumstances, present applications.
None of the defendants are served.
Only one defendant, my lord.
Only one defendant.
Yes, my lord. In fact, my lord, there's a criminal case going on in Uttarakhand. Over there, my lord, the police have.
The petition is agreed with the order dated 1/8/2025, whereby
25.
25. I'll set aside this order and will remand the matter to the court.
It may be allowed, my lord. It may be allowed instead of remanding
Court
it.
pass an order looking at your affidavit and other things.
Obliged, my lord.
The agreed with the order dated 1/8/2025, whereby the court has refused to permit the petitioner to issue suit summons by way of email. Land counsel for the petitioner submits that this order passed by the court is in this order dated so and so by so and so. Look at it and write. It is a land counsel appearing for the petitioner submits that this order passed by the court is contrary to the circulars issued by the High Court from time to time. It is submitted that in compliance with the High Court circulars, the petitioner has filed his affidavit and also he has filed the documents to show that after the interim injunction is granted, when the petitioner has sent the mail that was replied to by the respondents, which clearly shows that they are aware of the proceedings, and wantonly the defendants are refusing to receive the notice, and the court, without considering all this, has passed this order. This is a suit of the year 2025, and so far the notices are not served on the defendants, and the court ought to have suit of the year
24, my lord.
a suit of the year 24, and so far the notices are not served, could not be served on the respondents, and the court ought to have considered the application that's filed under section 151 CPC. Next para, having heard the counsel for the petitioner, peruse the order. When an IA is filed under section 151 CPC to issue suit summons to defendants by way of email, and also having complied with all the formalities as laid down by the High Court in the circular dated
My lord, 17/2/2025.
17/2/2025, the court ought to have considered the same, but the order impugned reveals that the court has failed to appreciate any of the contentions. In that key of the matter, this court is passed the following order. The order dated 1/8/2025 is set aside. The trial court shall consider the IA filed under 151 CPC
And order
issue
5.
suit summons to defendant by way of email expeditiously within a period of 1 week from the date of receipt of the copy of the order. The petitioner is at liberty to advance. When is the matter coming?
My lord, day after, my lord.
Where it is submitted that the matter is coming up day after. The court shall consider the same. This order, give it by tomorrow. So by tomorrow, this order shall be uploaded.
My lord, my application was under order 5 read with 151.
Order 5 read with 151 application. Yes.
So number 17, Omkar Basaprabhu, petitioner.
I'm withdrawing the same as not pressed.
The memo is filed stating that the suit itself is decreed on 25th June 2026, and this petition has become infructuous, and the petitioner wants to withdraw the same. Memo is taken on record and dismissed as withdrawn. Yes, 18.
So number 18.
Grateful.
K. Vijay Kumar.
Yes.
Millard. Petitioner is defendant number 7 in OS number 2147/2015. She filed an application for transposer from defendant to plaintiff.
What is the suit for?
Partition, Millard.
Oh.
My application.
Why do you ask them to come to the court?
Millard.
Why should they come to the
Keep
court?
on telling not to come, Millard. They are saying that I'm 80 years old. I have to see the result before I die. Like that, she's keep on telling me.
So, but she does. Yes, understand doesn't matter. It all depends upon the matter, merits of the matter, whether it is 80 years or 8 years.
Millard.
Yes.
Plaintiffs are colluded now. They are trying to, settle the matter with the builders. Now this defendant want to transfer herself from defendant to plaintiff. My application.
Let's see. What is your application?
Please, Millard. My application is at page number 25, Millard.
20.
Sorry, 23. My 21 annexure A.
Let's see.
Please. 24 may be looked into. Lengthy cast title is there, my lord. Page 24 may be looked into.
Who is the plaintiff? What is the relationship between this defendant and the plaintiff?
My lord, this defendant is second wife's daughter. First plaintiff, my lords, is the first wife's daughter. She is no more, and subsequent LRs came on record. They have filed statement of objections at page 28, may be looked into. That my application was filed on, my lords, 12/9/2025. They filed statement of objections on 14/10/2025. No orders was passed. Only my confined prayer is to consider my application at the earliest. That is the prayer before this court.
Is there any injunction restraining?
No, no.
Now please come to the order.
Hello?
Order.
No orders passed, my lords, but that my prayer is to consider my application. My application is kept in abeyance. At page, my lords, 63, my lords, last page. Matters keep on adjourning, my lords, from last. 62, my lords, last page of the orders. No orders passed on my application. My prayer is direct the trial court to consider my application.
When did you file this IA?
My lords, my application was filed on 12/9/25, my lords. Their statement of objection, my lords, 14/10/2020. 14/10/2025.
When was the hearing concluded?
And same day itself, they have addressed their argument at the time of filing of the statement of objections. It is shown in the order sheet.
Please come. Then count the writ petition is filed in the following prayer. Then counsel for the petitioner submits that. Right from. The court has heard both the parties on the IA that's filed with the petitioner, defendant to transpose him as a plaintiff, as it is alleged that there is collusion between the plaintiff is alienating the properties and colluding with some by entering into agreement with the developers. The court has heard it on 15/11/2025. From 15/11/2025, the matter has come up on 12/12, 13/1, 28/1, 19/2, 7/3, 12/3, 16/3, and on 27/4/2026. Then the matter was, then it is adjourned to, when is it coming?
Today it is there before the trial court. Today also I requested my colleague to pass it over. I am ready to address once again also. They are not ready to pass the orders.
No, what happened? Today matter reached.
Matter reached, I requested to pass it over.
Why?
Once again address the argument and request the trial court to
No,
consider.
what address you? That matter is coming up for pronouncement of orders.
They are not passing orders, Miller. The order sheet speaks, Miller. I am not making any false submission. See the order sheet.
No, no. Why you want, whether the court is passing the order is not his only question. I'll take it up at 2:30. What will happen, you tell me? Then we'll see. If the court is passing the order, then there is no order necessary. Yes.
Miller, they are not pass it over for orders.
But for what?
Matter is passed over for hearing the matter once again. Now the regular court is not there. Now it matter came up before the in-charge court.
Before in-charge court, what arguments you will advance when already the matter is resolved by the other court?
Well, the trial court is demanding me to address the argument once again on the application.
Then counsel for the petitioner submits that. So on whenever the matter comes up, because of rush hour, the order could not be released. And this is going on from the last 6 months, considering the submission of the land counsel petitioner. This court is passing the following order. No, the judge is not there. Who has reserved?
No.
Then this court, he has to hear the matter then.
Timeline may be fixed, Miller. I am ready to address.
When that judge was transferred?
1 month over.
When did you file this writ petition?
24/6.
Then what is the purpose of filing this writ petition? That matter has to be heard by the whoever is the presiding officer now. Yes, let them hear. Yes, next matter. It is submitted that it is posted and the earlier presiding officer is transferred. Now the presiding officer is insisting to argue on the merits of the matter. It is the petitioner has to argue the matter on the merits of it. And basing on the earlier hearing made by the other officer, the present officer cannot pass an order in that view of the matter. The writ petition is disposed of, directing the requesting the trial court to expeditiously hear the matter.
Please.
It's all waste of court's time and.
Inuta P. Kale.
Yes.
But in this case, I represent the petitioners. Petitioners, my lord, have filed a suit for declaration and injunction, my lord. After, along with the plaintiff, my lord, they have filed an application seeking an interim order of injunction not to alienate the suit schedule premises. My lord, the defendants and the respondents are the brothers and their family. Now, my lord, based on the registered partition deed.
What happened to the IA?
My lord, the IA came to be ordered as a issue emergent notice on the ground that there was no prima facie case has been made out. May I read impugned order, my lord, page 178.
Yes, we'll set aside that order and we'll remand the matter. 170?
178, my lord. May I read the order?
No, I'll set aside this order.
Please, ma'am.
Then counsel with the petitioner, before the petition is agreed with the order dated 14/6/2026.
4/6, my lord.
4/6/2026 in OS number 1071 of 2020, in I number 1, in OS number 1071 of 2026, with the first is ASCJ, Bangalore Rural District, Bangalore, whereby the lineage judge, without passing an order on the interim injunction application, has issued emergent notice on I number 1 and suit summons to all the defendants. It is submitted, and counsel appearing for the petitioner submits that the suit is for declaration and permanent injunction. The court, while issuing the suit summons, have observed that the plaintiffs have to make out the prima facie case that there is an immense threat to the rights of the property and the properties are in danger or being wasted. Therefore, at this juncture, prima facie, there are no sufficient grounds to grant an ad interim ex parte temporary injunction as prayed for, and hence the court has issued emergent notice on I number 1 and suit summons to all the defendants. When counsel appearing for the petitioner submits that by this kind of an order, the court cannot say that there is no prima facie material as the order is bereft of reasons. It is submitted that the court has failed to consider the application in its proper perspective. Then counsel has relied on a judgment of a coordinate bench of this court in so and so, so and so. They have it, you take it in so and so. Relying, and it is submitted that when an application is filed seeking ad interim injunction, the court has to consider the same on the merits of the matter. But on this way of a cryptic order, the court cannot give a finding that there is no prima facie case, and court ought not to have issued suit summons. Considering this court has having heard the counsel for the petitioner, produce the material on record. The court, without giving any reasons, and by order impugned, has observed that there is no prima facie case and issued suit summons to the respondents. When an IA is filed, the court has to deal with it on the merits of it, and on the top of it, the court cannot give a finding by way of this or by way of a cryptic order that there is no prima facie case. In that view of the matter, this court is passing the following order. The order dated so and so is set aside as far as the finding with regard to the prima facie case. The next paragraph. On the next date of hearing, the trial court shall consider the IA number 1 as expeditiously as possible. I shall consider the same within 1 week from the date of receipt of the copy of the order. Petitioner is permitted to permitted to advance make a mention seeking advancement of the matter. Notwithstanding the fact that the suit summons are not served, still the court should hear the
Much obliged.
So number 20.
this order also urgent. Yes.
20.
Appearing for the petitioners, my lord. My lords, I kindly seek for adjournment, my lords.
This is matter in the month of September. Yes, next 21.
That's my lords.
Yes, Nagraj.
Petitioner, this is a dependent number 1 to 4 writ petition.
Yes.
The respondent number 1 to 3 filed the plaintiffs filed the suit for partition in the year 2017. In the year 2026, they have filed 3 applications. One order 39 rule 1 and 2, restraining the defendants from putting any constructions on item number, survey number 98 of 2 acre 4 guntas. And another application under order 39 rule 1 and 2, restraining not to change the nature of the land. And another application on the same day under order 7 rule 14 3 of read with 151 of CPC for production of the additional documents and condoning the delay of filing the applications for the production of documents. All the 3 applications, common order has been passed at annexure A. But here, page 24 may kindly show whether the plaintiff, whether 23, whether the plaintiffs have made out prima facie case, whether the balance of convenience lies in favor of the plaintiff, whether irreparable loss and hardship is going to be caused to the plaintiffs, which cannot be compensated in terms of money in respect of temporary injunctions not granted, whether the plaintiffs have made out sufficient grounds to condone the delay in production of a document. Here, in point number 4 is concerned, nowhere is discussion is there in the order. In the para, point number 1 to 3 reasons is assigned. Nowhere it is stated how to condone the delay in sufficient grounds. It is not been explained. We simply allowed all the 3 applications by passing the common order.
No, if the injunction is granted.
Injunction is granted not to raise the
You can't file an appeal against this.
No, that is the MFA, that is on that application is concerned. Here,
Only on that last application.
last application.
Number?
IA number 24. Here, all the 3 applications is passed 22, 23 and 24.
And as far as this is concerned, there is no finding.
There is no finding. 24, IA number 24 is concerned, and there is no finding, no points is there.
Please come. When counsel appearing for the petition submits that court has passed an order on IA numbers
22, 23 and
22 to 24. It is submitted that IA number 24 is
24 is concerned. Order 7 rule 14.
IA number 27 is filed and order 7 rule 14. And in the common order, the court has framed an issue whether the plaintiff have made out a sufficient grounds to condone the delay in production of the documents without there being any finding on the same. The court the court has allowed all the applications. This court has perused the order considering the submission of the land counsel to the petitioner. There shall be stay of all further proceedings pursuant to the order dated so and so. Same notice to the respondent. The petition is permitted to take out hand summons and shall file a memo to that effect by 28th July, or else the stay granted by this court stands vacated.
22.
Stay may be further proceedings stay.
As granted.
22. Nandan.
For petitioner, the petitioners are the LRs of third defendant. The LRs of third defendant. Now what happened? The first defendant, see mother, the plaintiff and defendant number 229 are the children of first defendant. her husband died prior to her death, my lord. What happened, my lord? The property, the first defendant.
What is the IA?
I am, my lord, seeking, my lord, framing additional issues, framing of additional issues.
What were the earlier issues?
Earlier issue, my lord, I issue at page number, my lord. This is the reason, one submission.
No, I'll
Third
hear you.
defendant.
No, I'll hear you. First, come to the, what are the earlier issues? and what are
Earlier
the-
issue, page number 37. Whether the plaintiff proves that the suit schedule property is the joint family property of plaintiff and defendant number one, whether the defendant number one proves that the item number one of this property belongs to one Kalamadaya, son of late Kaji Chamaya, and he has adopted the defendant number one and has
Precisely.
executed.
Now, what are the
registered-
issues to be, additional issues to be framed?
Additional issue, subsequent, what happened, that's the reason. The first defendant blood claimed that blood, the property bequeathed or paternal uncle under registered will dated 26/19/74. So during the pendency of this case, the first defendant also executed one will. Will dated 11/5/2020, 11/5/2020. She died 8/10/2022, 8/10/2022. Subsequently, what happened? Third defendant died. So, LRs, the petitioner brought on record, they filed additional return statement on 11/3/2025. In the 11/3, in our return statement, we claims that the first defendant bequeathed executed a will wherein bequeathed the suit schedule properties in favor of defendant number 2 to 9. So, we subsequently what happened? We examined the scribe as well as attesting witness before the court as DW2 and DW4.
Right.
Subsequent to what?
No, 1 minute to save the time. If you just point out what is your application.
Application, IA number.
It will be easy
Sorry,
for me to understand and it will save the court's time.
Sorry, sir. Okay.
Yes. Yes.
IA number annexure G,
Yes.
and whether the defendant number 3A proves that the first defendant has executed the will.
Affidavit, that's fine.
In this affidavit, in para number 2 in the, I do swear that the plaintiff has filed the suit against me and other defendant for the relief of partition and separate possession in respect of the suit schedule property. During the pendency of the suit, the plaintiff was died. After death of plaintiff, the LRs have filed application under 22 Rule 1 and 2 CPC. After contest, the Honorable Court has allowed the said application and they have come on record. I do swear that during the lifetime of first defendant, she has filed a detailed written statement and taken good contention to urge before this Honorable Court. The first defendant in this written statement in para number 4 clearly stated that the suit schedule property are self-accord property of the first defendant and she has absolute rights over the so-and-so. Next para. I do swear that during the pendency of the suit, the first defendant was died on 8/10/2022. During the lifetime, the first defendant has executed a will on 11/5/2020 in favor of sixth defendant. In the said will, the first defendant clearly stated that after her death, all other defendants are equally divided the suit schedule property and enjoy the same. So,
I've seen that. Please come to the order now.
Order, annexure J minute, page number 49 minute. Order number 30, page number 49 minute. The land counsel for the defendant number 3A filed the present application under order for 14 Rule 5.
You can come to paragraph 7.
Paragraph minute?
7. That's
7.
the reasoning part.
Okay. Admittedly, the plaintiff have filed the present suit against the defendant for the relief of partition and separate possession in respect of the scheduled property. The defendant number 3A has contended that in her written statement that the first defendant during her lifetime executed the will dated 11/5/2020 in favor of defendant number 2 to 9. Hence, the defendant number 2 to 9 are the absolute owner in possession, having right, title, and interest over the same. Now, this application, the defendant number 3A is seeking the prayer to frame additional issue with regard to the defendant number 6, who is alleged to have bequeathed the will by defendant number 1 in his behalf, which is contrary to the pleading taken by the written statement. Hence, there is no ground made out by the application. Okay. The application is dismissed. In the will, the first defendant.
There is a finding here which is contrary to the pleadings taken up in the written statement. What is your pleading in the written
In
statement?
the pleading,
With regard to defendant number 6.
no. That is the reason, madam. Kindly peruse, my lord, additional written statement filed by the petitioners. My lord, page number annexure D, page number 30, my lord. Page number 30.
Yes.
In para number 5, my lord, para number 5, page number 33, bottom only, last para.
Yes.
This is the written statement of petitioners here. The further, it is further submitted that the first defendant died on 8/10/2022, left behind by her, the defendant number 229, only LRs to succeed the asset of the first defendant. The first defendant during her lifetime has executed the will dated 11/5/2020 in favor of defendant number 229. Hence, the defendant number 229 are the absolute owners.
Now, where is the, where it says, why the, what is that finding that it is contrary to your written statement?
There is no contrary. There is no contrary, my lord.
Please come.
In the application,
The petition is agreed with the order passed by the court on item number 13, dated 17/4/2026, whereby the court has dismissed item number 30, filed with the petitioner to frame additional issues. When counsel submits that, the court gives a finding that by this application, the defendant number 3A is seeking a prayer to frame additional issue with regard to defendant number 6, which alleged to have been equipped the will by defendant number 1 in his behalf, which is contrary to the pleadings taken up in the written statement. And there are no grounds made out. Petition has drawn the attention of the court to the written statement. It is submitted that this observation of the court is contrary to the findings of the contrary to the written statement filed with the petition herein. Considering the same, they shall stay of all further proceedings pursuant to the order date so and so. Same, the notice in addition and summons memo by 28th or else a stay granted by this court stands vacated.
Kindly dispense the notice, defendant number 4 to 4 to 9, because this
Memo is filed seeking dispensation of notice to defendants 4 to 9.
4 to
9.
4 to 10, madam. Sorry, 4 to 10.
10. Notice to 1 to 3.
1 to, along with notice to 1 to 3, and also iron summons. Great.
Yes.
Hearing for petitioner. So petition against filed against the DISCOM. There is a threat of disconnection of electricity here. It's in page number annexure.
Anita, where is that panel council? BESCOM. Mr. CH-19 is directed to take notice on behalf of the first and the second respondents. Please serve him. I'll take it up tomorrow in the first. This is matter to print the name of Mr. So-and-so. This is matter tomorrow in the first list. Then counsel the petition is permitted to take out hand summons on the counsel. No, not hand summons. He is permitted to serve the copy of the writ petition. Yes, tomorrow.
24.
My lords, I am appearing in item 24. My lord, this is connected to a writ petition that is already pending before your lordships, which is writ petition 13260 of 2026. What is being challenged here primarily are the CRC deviation settlement mechanism regulations. There was a stay that was granted.
Yes, my lords.
Is it part of the batch matters?
This is the fresh writ, my lords, but challenging identical same regulation which have been challenged in these writs.
Take that. Give the writ petition. The other matter is not listed.
No, my lord, the other matter is not listed. This has come up for the first time. If your ladyship will consider, my lords, passing the same interim order. My colleague has just handled. Yes, I'm obliged.
You appear for
Well, I'm appearing for the petitioner, my lords. Wind World, Wind Farms and
Who are the
others.
respondents?
Well,
For the respondent number 1,
respondents,
2 and 4, my lords, I'll accept notice.
1 minute. Respondent,
Union of Indian Mills. R1, R2 and R4.
1, 2,
And 4.
1, 2 and 4, so and so. Accept notice. Then what about 3?
Notice would have to be.
notice will have to be issued to 3, 5, 6, 7, 8.
Regulatory Commission, some advocate is there. Morning somebody was mentioning. And what is his name? Mr. N. Prakash is director to take notice on behalf of the third respondent.
Malon, may I just, I'm sorry to, but this is the Central Commission. So I don't know whether your lordships have a standing counsel for the Central Commission. I know for KERC, yes. Yes,
Notice to respondents number 3, 5, 6, 7, 8.
9 may have a standing counsel, my lords.
Karnataka Power Transmission Corporation.
That's the KERC, the state.
Mr. Prakash, no?
KPTCL.
Sorry, KPTC. KPTC.
SLDC. Panel counsels for.
Sumana Naganan. Mr. Sumana Naganan.
Sumana Naganan is director to take notice on behalf of the 9th respondent. Then counsel appearing for the petition submits are in the similar matters, already interim orders are passed. They relied on an order passed dated 27/4/2026 in WP number 13260 of 2026. In the light of that order passed, considering the order dated so and so, this court is passing the following order. The operation of as it is, the petitioners are willing to continue under the earlier DSM regime and comply with the existing deviation norms. The operation of regulations 6(2) within brackets 2 within brackets B and 8 within brackets 4 of the DSM regulations 2024 shall not be enforced against the petitioners to the extent of revised formula and enhanced penalties till the next date of hearing. The petition shall continue under the earlier DSM regime. Deviation up to 15% shall be governed in terms of the earlier framework, and the petition shall pay deviation charges accordingly. Is the list along with that number? Yes.
25.
Yes.
Notes in a suit for specific performance, in order to not to alienate or encumber or the property was sought for, as per page number 19, my lords, only notice was ordered.
Where is that?
Page number 19, my lords, 19. Plaintiff.
21/11/2026.
Yes, my lords.
Please come. Agreed with the orders passed on I number 1 dated 3/7/2026.
Please.
Whereby the court has granted, instead of considering the IA number 1, court has issued the emergent notice to the defendants. The plaintiff is before this court. Then counsel appearing to the petitioner submits that when an application is filed, like in the other case, I said, same, in the light of the same, this court is passing the following order. In that case, take this order. It is submitted, the counsel appearing for the petitioner submits that when an IA is filed seeking ad interim injunction, the court has to consider the same on the merits of the matter and pass an order. But the court cannot issue suit summons. He has relied on judgment of passed by a coordinate bench of this court in so and so, so and so. Next paragraph. Considering the order passed, having heard the counsel of the petitioner and considering the arguments, considering the order that is passed in so and so, this court is passing the following order. The trial court is requested to pass orders on I number 1 within 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the suit summons are not served on the defendants. petitioner is at liberty to make a mention for advancing the matter. Yes,
Then number
Grateful.
26, Ashok T.
yes.
Hearing for petitioner, my lord. Petitioner is a defendant number 2 in OS number 184 of 23. It is sought for declaration of property. We had filed a IA number 14 for stay the proceedings because we had initially filed a OS in 106.
Please come to the order. Let's see. Come to the impugned order. Please read from paragraph number 7.
The sole contention of defendant number 2 is that he had filed suit in OS number 106 of 16 for relief for partition in respect of suit properties. As such, that suit was disposed and RFA is preferred before the Honorable High Court of Karnataka in case must stay as per section 10 of CPC. It is relevant to note that the RFA is filed by challenging the disposal in partition suit. Moreover, the instant suit is for declaration and consequential relief of permanent injunction. The defendant number 2 has filed following case WP number 22311 of 2019 in Srimati Arasamma and Lakshmi and others, where an Honorable High Court of Karnataka gave findings that section 10 of CPC can be filed at any stage of the suit of an appeal is considered as contusion of the suit. National Institute of Mental Health and
What is the relationship between the parties in the earlier suit for partition?
same parties, they are the relatives, my lord, same parties and same subject matter, my lord, in both the suits.
This plaintiff is arrayed as defendant
number.
And this suit scheduled property is part of the partition suit.
Yes, my lord.
Where did you say so? Please come to your application. Affidavit, where is the affidavit?
Page number 24.
24.
Paragraph 44, I state that OS number 106 of 16 filed by me and my sister, who is defendant number 4 in the present suit, seeking the relief of partition and separation possession in respect of 16 items of immovable properties, came to be partially decreed by the judgment and decree date 23/2023 passed by the Honorable Court. And I further state that the present.
Then counsel for the petitioner submits that. Earlier, OS number 106 of 2016 was instituted seeking partition between the very same parties. And after the suit was decreed, the appeal was filed and the same is pending consideration. And one of the parties to the suit has filed a suit for declaration of title and injunction in respect of the very same properties. That came properties, it is submitted that the court has failed to consider the scope of section 10 of the CPC. Considering the same, they shall be stay of all further proceedings in OS number 184 of 2023 till the next date of hearing. Notice to the respondents, the in-person, in addition, hand summons memo shall be filed by 28th of July or else the stay. Yes, next.
27, Arvind N for petitioner.
Appearing for petitioner, my lords. My lords, I have challenged the review petition. My lords, the facts of the case is, my lords, the petitioners has filed a suit for partition. My lords, the partition suit was decreed. And my lords, I have preferred a FDP, my lords. In the FDP, my lords, when the suit was, when the proceedings was pending, one of the petitioner was died, my lords, having no legal heirs, my lords. My lords, before the trial court, my lords, the petitioners has filed application for modification of the shares, my lords, which was before the trial court, before the decree, my lords, it was held that 1/5 share, my lords. After the death of the person, it has become 1/4 shares, my lords. For that, my lords, we have seek the modification of the decree, my lords,
Where is
my lords,
that
which
order?
was, my lords, it is at IA is at page number 43, my lords, annexure E,
Page number?
43, my lords. When the FDP is pending itself, my lords, we have filed the application. 43 annexure E, my lords.
Is allowed.
My lords, which was dismissed, my lords, which is at page number 53, my lords. IA under order
What
152.
is this at page 41?
43, my lords, the application which I have filed, my lords, for the modif.
141.
140, 152 red.
41.
40.
Page number 41.
My lords, page number 41 is FDP proceeding, final
It
order.
is, now the DB proceedings are not pending.
It's concluded, my lords. Later, my lords, I have preferred a revision petition, my lords, which is the order is at the order starts from page number 58, my lords.
50?
58, my lords.
Let's see that.
The review petition I have filed under 114, read with 41. My lords, here, my lords, the court has observed that, my lords, when the plaintiff dies, my lords, with no heirs, it has to go to the, as per section 29 of the Hindu Succession Act, it has go to state, my lords, it has been observed by the revision petition, my lords. My lords, here, my lords, when the plaintiff died with no heirs, my lords, it has to go to agnates and cognates, my lords.
You already FDP is concluded. The petition is permitted to take out hand summons.
Let's
council appearing
the
for
liberty
the
may be
respondent.
reserved to contest the same contention in the execution proceedings, my lord. That observation may be disposed.
Without the other side, how can this court pass order? Once the memo is filed, is this matter?
Much obliged.
28. Keshav M. Datar.
Preparing for the petitioner, my lords. This is a suit for eviction. The issues have been framed. I'm challenging an application for which has rejected my application for striking out of issues. The issues that was framed is at page number 60, my lords.
Page number?
Issue number 4 is what I have in grievance with. Page 60.
60. Yes.
Issue number 4, whether the defendant proves he is not liable to pay any amount as the plaintiff has failed to issue GST bill. My case before the trial court is that the plaintiff has failed, but I will never be able to prove this issue.
But who pleads it?
My lords,
Who pleads it?
I plead it, but this is a negative issue casted upon me. Now the plaintiff can prove if he has issued a GST bill.
Whether the defendant proves that he has rectified
He is not liable to pay any amount as the plaintiff has failed to issue.
4.
Please, my lords, issue number 4.
Whether defendant
Proves that he is not liable to pay any amount as the plaintiff has failed to issue a GST bill and a remittance certificate. Now, if only the plaintiff can issue a bill is when there is a liability cast on me for me to pay that bill. Now, my case is that there is no bill. Now, if I am made to prove whether the plaintiff has proved, this is a negative issue.
Please come to the order.
My lords?
Order.
My lords, the order was not annexed because of it was not made available.
Then what are your question?
My lords, I'll file it by way. It
No.
got released.
When this was numbered, what your question?
I have filed a dispensation and I've put an online copy, but the order is now available. My lords.
Yes, page number.
My lords, page 2 is the impugned order.
Let's see.
My lords, kindly come to page 7, which is the reasoning. The relevant portion starts from page 8. Third line from top, my lords. Page 8, third line from top.
We'll read from para 8.
Please, my lords. On a perusal of the written statement filed by the defendant, at para 3 of the written statement, the defendant has contended that in terms of the lease deed dated so and so, the plaintiff was required to issue GST bill and a remittance certificate. Since the plaintiff has failed to issue a GST bill and a remittance certificate, the defendant has not paid the rent to the plaintiff. On appreciation of these facts, it is evident that the defendant has raised a defense that in terms of the lease deed dated so and so, the plaintiff was required to issue a GST bill and a remittance certificate. The plaintiff has denied the said fact. As per Order 14, Rule 1 of CPC, if a material proposition is affirmed by one and the same is denied by the other, the court has to frame an issue with respect to the said material proposition. As stated up.
Will issue this GST bill and remittance certificate.
Now, my lords, that is for the plaintiff to prove. I am the defendant. Now, if the burden of
As
proof,
per that's your case,
Please,
that as per the lease deed, this GST bill and remittance certificate
Was
has to be issued.
as to-
When were you inducted into the property as a tenant?
my lords, in the year 2022. In the year 2022, I've been inducted into the property as a tenant. I have paid certain amounts.
No, as per the covenants of that deed, he has to give you this. How
Yeah.
he will give you?
My lords, he has to raise a bill by specifying the GST amount, which is now reduced. Back then, it was 18%. He has to give me a bill with the GST amount. I make the GST payment with the GST number that.
The plaintiff.
My lords,
What is the case of the plaintiff?
non-arrears of rent.
With regard to this GST and.
There
other
is
things.
no averment to that effect. Kindly see the plaint. There is no averment with respect to GST or the remittance certificate, or whether they have done that. Now, the burden of proof comes, if my lords could see the Evidence Act, the burden of proof will come when I say he has not done an act, for him to prove that act whether he has done it. But I won't be able to prove whether he has done that act. Kindly see the Evidence Act.
No, please read it.
Please, Manoj. As stated above, the third line, Manoj, as stated above, the defendant has contended that the plaintiff was required to issue the GST bill and a remittance certificate as per the lease deed.
Then counsel for the petitioner submits that. When the petitioners file an application, the striking of the issue number 4.
Issue number 4.
That was rejected by the court. It is submitted that when the plaintiff has filed the suit, burden lies on him. And the court cannot place a negative burden on the defendant, which the defendant would not be able to discharge. And this aspect was not considered for the court. Considering the same, they shall be stay of all further proceeding. Question to so and so. Same 28. Memo shall be filed, or else the stay granted, but this court stands vacated.
Manoj, the matter is on Friday. May I seek for hand delivery, Manoj?
That's what I have granted.
Hand delivery, Manoj. Grateful.
Yes.
Grateful.
That is it, sir.
Lords, list 2, serial number 24. From 22/6 to 29/6, this matter was being listed in list 1, my lords. Tomorrow is the judgment before the trial court. May be taken up in list 1 tomorrow, my lords.
For that, you should have given a memo in the morning. Why are you mentioning now?
But it's in the list, my lords, as for.
That I would have seen in the afternoon. I've seen all the memos.
Apologies, my lords, since the judgment is tomorrow, my lords, I'm making the mention.
Now what happens? Everybody will start now. And it's difficult for the court to manage all that. So I'm rejecting
I was
your
the
request.
assumption that the page-wise list will be called out in the morning, my lords. It was not called out.
That give it to the court officer, whatever your request is. That I'll consider in the afternoon.
Grateful.
Yes.
Passover matter,
May I make one submission?
No submission. Yes.
number 1, serial number 8, Passover,
Represent the petitioner, my lord.
Gopal Naidu.
What are your instructions?
As far as years of power.
Now, what is the order that is questioning?
Lord, the
To
petition-
consider representation
representation is at annexure
by
F, my
continuing
lord.
the power connection till the
Annexure
regular
F and H.
power connection is allotted to the building by ignoring endorsement 7/11/2025. What is that endorsement?
The endorsement says, my lord, the occupancy certificate is required, ownership of the premises or proof of ownership is required. That is the endorsement that has been given. I am the tenant under the second respondent. The notice is served on the second respondent, but she has not appeared before this honorable court. She has put me in position, the second,
You are the
I am the
tenant.
tenant.
Hmm.
The power was, I was enjoying the power. At the interview,
When were you put in possession of the property?
I was put in property in 2023. I had, the building had power. Temporary power connection was obtained by the landowner.
Temporary power connection will not run forever.
Not-
Power connection has to be as per the as per their own provisions and as per their own.
I am prepared for that. Even the regular power, whatever the charges they levy, I am prepared to pay.
It is not, regular power connection will be given to you provided the requisite documents are there. It will
Milord.
not grant.
Milord, I will take Milord to annexure B, Milord, annexure B. Annexure B, this honorable court has passed an order earlier when similar situation was arisen. The respondents, the first respondent have restored the power connection.
No, please understand. I cannot look at some order passed by a coordinate bench of this court without me being satisfied with the content.
I agree with you.
Now,
I agree with you.
you say a representation is given saying that I am the tenant, don't ask for anything, but you continue my power supply.
No, Milord. I have given all the documents. I have enclosed along with my representation.
Then you are saying that notwithstanding the fact that so and so documents.
Milord, may kindly, I will take
But
Milord.
if you are furnishing all the relevant documents which are required for them to give a permanent connection, that they will do. But I will not say, notwithstanding the fact that you don't supply all this, give him the exemption.
No, I am not saying that, Milord.
Please come to your prayer.
Milord, before going to prayer, Milord, I will take Milord to annexure F, page 30. Ink page 30. What all I have given before the first respondent.
I am not concerned with what you have given. What is required, that you have to give.
Milord, I have already furnished. That's what I am saying.
But now, please come to your prayer. You can't submit something contrary to your prayer. Please come to the prayer. We'll see what is that you
Yes,
ask.
Milord. Yes, Milord. It is at
Yes. Page 8.
ink page 8, Milord.
Hmm.
Issue a writ of mandamus directing the first respondent to consider representation as per annexure F by
What are
continuing.
you doing from 16/10/2025 till?
I have been fighting it out by filing the writ petitions.
When
I'm
did you
fighting
file
it out.
the
The
writ
writ-
petition?
This is the third writ petition I have filed.
Let us see the writ petitions.
Milord, annexure. One second. Annexure B, Milord. Annexure B is the first writ petition that has been filed. As soon as the power was disconnected, I have filed the.
20th July 2022, one writ petition.
Yes, Milord.
Yes.
Milord, I will take page number 14 of the same annexure B, Milord.
I have read it.
Milord, para 2, Milord.
I've seen that.
Yes, Milord. Subsequently, I have preferred annexure C before them.
Suit, yes.
Then, my lord, they have sought the details on the basis of annexure E. Even that has been complied by me. The two orders have been communicated to them and have completed all the orders. But in spite of that, they are not providing the power, restoring the power. They are not restoring the power.
Please come to the prayer.
Lord,
Come to the prayer.
prayer, yes, my lord. Annexure F and G I have sought for. Lord, issue a writ of mandamus directing the first respondent to consider representation dated 16/25
As far as that is concerned, court has no difficulty.
yes, ma'am.
Next, the second part.
Power connection is allotted to the building by ignoring endorsements issued annexure G dated 7/11/25 bearing number so and so, and annexure J dated 20th/12/25 seeking NOC from the second respondent bearing so and so. My owner is not cooperating with me because we have
What is the
litigation.
electricity department?
We have litigation between us. Myself and the second respondent.
This court cannot direct them to do something contrary to their terms and conditions.
Lord, she is suffering from without amenities, my lord.
No.
There
that
shall
we
there
can't- that
there
we
shall be
can't
some
do.
equity, my lord.
Whatever I will say to consider your representation and provided whatever the requisite documents that you furnish to them, then they will consider. Otherwise, no.
May I request one thing, my lord? So far as the documents which have been directed by this honorable court to be furnished to the respondent, first respondent, I have complied as per annexure H. And this may kindly be noted, my lord, in the order. I have complied, I have produced all the documents.
This is going above and above your prayer. You said consider your representation. As far as that, I have no difficulty. I'll ask them to consider your representation. And in accordance with law, let them pass orders. In accordance with law, if they require the documents, they will ask you.
So it may kindly be, it may kindly be.
Assist the court.
Yes.
Two things. Annexure G, Swami, in 2025 November, we have issued the intimation asking them to furnish the renewal of the lease. It was lapsed in the year 2023 between the owner and the tenant. So it is doubted. Subsequently, kindly your lordship may turn to page number 20 of the compilation. Middle portion. The property was, the owner has lent the property with the Muthoot Finance. It was attached by Muthoot Finance. Now it is property in litigation. It is their hand. When that being the case, how the BESCOM authorities will be in a position to settle the matter of their money?
That you tell them.
That
Tell
is
him. That's what,
their,
precisely, that is what you have to tell him by passing an order.
That's why we have issued annexure G.
It is not.
So they'll comply with, they should comply with the annexure G.
In fact, it has not been mortgaged. It has not been attached by what they say.
Lease was completed. So you.
I'll ask him to comply with annexure G and J.
Yes.
And you come, you please pass orders within 10 days.
Yes.
Please come.
Yes.
The present writ petition is filed, seeking the following prayer. Is the case of the petitioner, the petition is the tenant and the second respondent herein. And give notice to the second respondent while considering this representation. The petitioner is the tenant and the second respondent. The petition's landlady had received a security deposit of rupees 27 lakhs and pays the petition in possession of the house. At the time of handing over the possession of the building was unfinished, and then the second respondent has requested the petitioner to carry out the remaining construction work at the cost of the petitioner and recover it from the second respondent. Accordingly, the petitioner has spent an amount of rupees 3 lakhs. The second respondent has intimated the first respondent to withdraw the temporary power connection to the property, though the petitioner was paying the consumption charges. However, the first respondent insisted NOC from the landlady to allow the petitioner to enjoy the power connection. Petition on 15/4/2022 has requested the second respondent are children and the first respondent to continue the temporary power connection. However, the NOC has not been issued with the second respondent. As such, as filed WP number 10913 of 2022. And basing on the submission made by the respondent, that they'll consider the representation of the petitioner and restore the temporary power connection on power connection. The writ petition was disposed of on 14/3/2022. It is a case that the second respondent under children have removed the electricity meter from the premises on 10/9/2024. Immediately, petitioner in a representation dated 10/9/2024 has requested the first respondent to restore power supply by fixing the meter inside the premises. He has also filed OS number 19 of 2024 against the second respondent under children for permanent injunction when they try to dispossess her from the property. And also filed WP number 27827 of 2024 before this court, seeking the relief of mandatory injunction against the first respondent. This court, by order dated 8/9/2025, has requested the petitioner to furnish all requisite documents to the first respondent. By order dated 8/9/2025, it is stated that on 16/10/2025, the petitioner has given a representation enclosing the documents such as rental agreement, print in OS number 19 of 2024, the termination notice issued by the respondent number 2 to the first respondent. Instead of considering the representation dated 16/10/2025, the first respondent on 7/11/2025 has refused on the ground that the lease deed is expired. The petitioner in a representation dated 26/7/2025 has clarified to the first respondent that suit for injunction filed against the second respondent and the children, and the same is also pending. And all a representation dated, this is 26/11 euro. It is stated that expiry of the lease period will not come in the way of the petitioner continuing in the property until the proper eviction in accordance with law. Further, the second respondent is not prepared to renew the lease agreement in view of the pendency of the suit and the termination notice issued. All these facts have been brought to the notice of the first respondent, requesting to restore the temporary power connection which was existing earlier. It is the case that the first respondent once again on 20/12/2025 issued an endorsement to produce the NOC from the second respondent herein. Hence the petitioner and refused to restore the power supply. Hence the petitioner is before this court. Next parallel, and counsel appearing for the petitioner submits that petitioner, there are disputes between the petitioner and the second respondent herein. Though he has submitted all requisite documents, the respondents are still insisting for the lease deed, which he will not be able to furnish as there are disputes between the parties. It is submitted that the respondent ought to have considered his representation and ought to have restored the power supply. And this has been going on from years together. Hence, it is submitted that the writ petition may be allowed by directing the respondents to consider the representation as prayed before this court. Next paragraph. Then counsel appearing for the respondent, respondent number 1 submits that the second respondent has mortgaged the property in favor of Muthoot Finance, and Muthoot Finance has taken possession of the property. And in the property which is in possession of the Muthoot Finance, now the petitioner wants his court to, the petitioner wants the restoration of the power supply for which he is not in possession.
Lease agreement is terminated on
It is submitted that
2023.
There is no lease agreement, and that itself is terminated in the year 2023. And on his request, and without as per the procedure invoked, they have asked for the documents. It is submitted that if the petitioner fulfills the criteria for granting of the power connection oblique supply.
KERC rule 4.02.
4.02. KERC rule 4.02. If he complies, they have no objection.
Proof of ownership.
They have no objection to restore the power supply. Next part, having heard the councils on either side. Next, this court is not proposing to.
Eviction, though it has been terminated the tenancy, but eviction has not been obtained by the
Counsel
second
for the
respondent.
respondent petitioner in response to that submits that even if the lease is not extended, unless and until the due process is followed and he is evicted from the premises, the respondents, premises, they have to restore the power supply. Next part, having heard the counsels on either side, peruse the material law on record. From the material on record, it appears that there are disputes between the petitioner and the second respondent. This court is not concerned with the interstate disputes between the petitioner. What are those rules called? You have a copy?
Right now,
Court officer, take a copy.
It says, my lord, the consent of the NOC from the landowner is required to restore power connection.
It's called, what are those rules called? Regulations are called?
Electricity regulation.
Karnataka State Electricity Regulation.
NOC required for providing the power connection.
As per the KERC regulations, the respondents are bound by the KERC regulation, and whatever the provision requires, the party who is seeking a power connection, either it is temporary or permanent, has to fulfill the set conditions. Though it is not for the petitioner to say that they should not insist for the NOC or any other document which the regulation.
Page 34, that relevant.
Page
34.
Annexure J.
Second paragraph. ಮುಂದುವರೆದಂತೆ KERC so and so proof of ownership of the premises of
KERC COS 4.02.
electricity supply for supply of electricity.
It is KERC COS 4.02.
Yes, that's
Whatever the regulation requires, it is for the party to comply with it. There cannot be any exception to the provision, to the regulations. In that view of the matter, without expressing anything on the merits of the matter, this court is passing the following order. The petitioner, the representation of the petitioner shall be considered by the respondents in accordance with law within a period of 10 days from the receipt of the copy of the order. The petition, whatever the requisite document, the documents that are required, the petitioners will submit. And as per the endorsement, if he is not able to submit any particular document, it is for the, if he is not fulfilling, it is for the respondents to pass appropriate orders accordingly. And before passing orders, the respondent shall also give notice to the second respondent herein.
Cell number 29, which one? Cell number 29.
The trial court has dismissed 6/17 amendment of the pleadings. The prior and the pleadings for the suit.
What is the suit for?
Partition, my lord.
Which year is the suit?
2022, my lord. And the only thing is that, my lord, instead of grant, we mentioned as purchased by my father, plaintiff's father. But the year of Venkatraman, my stage is crash of the DW1. On the earlier point of time, the matter is posted for the judgment and 16/4/2025. And again, the trial court has been recalled to permit the.
Because when you say that you have purchased it by waiver sale deed, that must have been denied by the plaintiff.
But what happened? Not like that, my lord. My father has been purchased. We pleaded in the pleadings, but my father has been purchased. Supposed to be mentioned as it has been granted to him. But this property is the Inam grant land, Jodidar Inam grant land.
So what were the issues? No, the
But
entire,
issues are there.
where are they?
In page number 31, whether the plaintiff, proved that she is a member of an undivided Indo giant family and the suit settled properties as the ancestral joint family properties, whether the defendant number 10 is would prove that the defendant number
It's a
7 to
very crucial aspect. Where is the question of forgetting it? There is an issue in that regard.
But thing is that, my lord, issue number 1 with respect to concern, the property is giant family.
According to you, you have purchased the property by way of 16/5/2022 document.
No, I have not purchased. One of the family member has sold in favor of defendant number 10. But we are the legal heirs of one Veera Enkappa. Veera Enkappa has 4 children. One of the children has been sold in favor of defendant number 10. Contestant defendant, respondent. Other respondent, the family members, they filed. Other 2 family members filed for the counterclaim. Means they want to also decree the matter. The matter we have adduced evidence, exhibit P1 to P12 has been marked and the argument has been posted for judgment on 16/4/2025. Well, after the posting of the
affidavit, why you wanted to do it now?
But in page number 32, my lord. 32 or 34. Admittedly, the plaintiff has a share over the property.
So please come to the order.
In page number 13 is the operation. In para number 10. The plaintiff has sought for the relief of the declaration that registered sale deed dated so and so by the defendant numbers in favor of defendant number 10 as not binding upon the plaintiff. The present suit filed on 27/2022, which is nearly 2 months later than the alleged registered sale deed. The one is for partition and the law presumes that the parties are in possession enjoyment of the said property. The present relief sought in declaration, which obviously reminds back to the date of the suit. There is no reason why the said relief is not sought for by the plaintiff at an earlier point of time when all the pleadings were brought the court and within the knowledge of the plaintiff. Therefore, at this belated stage, where the suit has come up for fog intent, the court laying upon the clause 617 cannot be permitted the plaintiff to amend the flag.
No, it says that you are seeking amendment to cancel the declaration.
No. We sought for earlier point of view. We didn't sought for the not binding. We didn't sought for the at the time of the filing of the suit. We are not sought for the cancellation or not binding. My lord. What happened? The trial court admitted
After the entire trial, you will seek it.
Yes, ma'am.
Please come. Agreed with the order passed in I number 17, invoice number 342 of 2022, date 15 June 2026, by the Principal Senior Civil Judge and CJM Kolar, the petitioner, who is the petitioner plaintiff, is before this court. After the evidence was, what was the stage you said? It was once decreed and remanded.
Sorry.
What was the earlier stage?
Earlier we stated the purchase from Krishnamurthy.
No. The suit proceedings I'm saying. It is posted for judgment.
Earlier posted for judgment on 16/4/2025. And later they filed an application, defendant number 10.
When earlier the suit was posted for judgment, after on the application filed by the defendant, the suit is reopened and the matter is posted for defendant's evidence. At that point of time, an application is filed under Order 6, Rule 17, seeking to amend the pleadings. Now, by virtue of this pleadings, the petitioner wants to seek a relief that the sale deed dated 16/5/2022, seeking a declaration that the sale deed dated 16/5/2022 is not binding on them, and also another pleading that the property is purchased by way of property is given to the father by way of a grant, but not by sale. The court, by way of sale deed, the court by order impugned had dismissed the said application. While dismissing the said application, the court has observed that the plaintiff sought for the relief of declaration that the registered sale deed dated 16/5/2022 by defendant number 7 in favor of defendant number 10 as not binding upon the plaintiff. The present suit is filed on 27/2022, which is merely 2 months later than the alleged registered sale deed. The suit is one for partition, and the law presumes that the parties are in possession and enjoyment of the property. The present relief sought is for declaration, which obviously relates back to the date of the suit. There is no reason as to why the said relief was not sought for by the plaintiff. at the earliest point of time, when all the pleadings are before the court and within the knowledge of the plaintiff. Therefore, at this belated stage, where the suit has come up to the bargain, the court, relying upon the provision of Order 7, Order 6, Rule 17, cannot permit the plaintiff to amend the plaint. The proposed amendment is neither an arithmetical nor a typographical error which can be considered, if it is allowed, would lead to multiplicity of proceeding and fills up the lacuna the plaintiff has suffered, and obviously changes the nature of the case, which is impermissible under law. It is the defendant number 1 who will be put to hardship and inconvenience if the application is allowed. Therefore, the court has observed that the amendment cannot be permitted at this stage and would not be necessary, and accordingly dismiss the application. Then counsel appearing for the petitioner plaintiff submits that by allowing these amendments, the nature of the suit will not change, and no prejudice would be caused to the defendant. In fact, the defendants are also entitled. Defendants are also entitled for the share in the property. Hence, the court ought to have allowed the application. Next, for having heard the counsel for the petitioner, peruse the material on record. The suit is filed in the year 2022. It is submitted that earlier the suit is posted for judgment, and then at the application filed by the defendant, now it is at the defendant's when it is at the stage of defendant's cross-examination, the plaintiff has come up with this IA seeking amendment by seeking a declaration that the sale deed is not binding on them. This court has perused the issues that are framed on 20/2/2023. The issue number 2 is whether the defendant number 10 would prove that the defendant number 7 to 9 have sold the property to the defendant through a registered sale deed on 16/5/2022. Whether the 2022. Now, after the already earlier the evidence is completed. Now, when the matter is posted for defendant's evidence, at that point of time, the petitioner plaintiff wants to amend the seek the relief of declaration that the same is not binding on the plaintiff. The court has rightly observed that the relief, this relief will release back to the suit, and further, there is no due diligence on the part of the plaintiff. All this sale deed is before the court, right? This sale deed is before the court right from the beginning. It is part of the pleadings, part of the issue, and now seeking a declaration at this point of time, as rightly observed by the court, it would prejudice the defendant number 10, and has rightly dismissed the application, and this point is accordingly dismissed.
Great.
Number 30. A&3 for petitioner.
Intervention. Previous matter, take notice has to be issued. EVS.
The so-and-so takes notice on behalf of so-and-so, and on instruction submits that.
Number 30.
Page number 18 minutes. Lord, it appears that the Gram Panchayat has written a letter to the BESCOM alleging that my construction is unauthorized and illegal, that there are more floors than what is necessary, and that I'm running a paying guest without permission. Lord, thereafter BESCOM's issues a notice to me saying that you please submit a representation to the Gram Panchayat, get a clarification from them within 7 days, otherwise I will disconnect your electricity. BESCOM itself has not independently verified, not independently conducted any spot inspections. Lord. It merely relies on a letter issued by the Gram Panchayat.
Oh, if it is, who has given you permission?
Lord, the BESCOM has given me permission for electricity, but it has not conducted an independent inquiry here. A letter is written by the Gram Panchayat to BESCOM saying that my construction is illegal.
Regulation permit them to do so.
No, I'm sorry.
Which is a regulation that permit the BESCOM to pass such an order?
There is nothing, Malo. That is my entire contention. It is not an order under
That is
126.
what I'm not able to understand in several cases. Also.
Yes,
now, if a particular construction is, there is any unauthorized construction, it is for the local authority
Exactly,
to take
Malo.
action.
Yes, Malo.
Then, if the BESCOM can act upon that, and they can, I mean, the power connection can be cut. Which provision deals with that?
Malo, it is not there. In fact, Malo, it is only a case of illegal use, or if I'm paying a tariff lower than what I'm supposed to pay. Here, in
But
fact,
all the cases are of that nature, what I'm finding. So,
yes, my lord, but
I thought
kindly see, my lord, in fact,
case I'll find out what it is.
my lord,
What
in
are the
fact,
powers
in
of
fact,
BESCOM in doing all this?
if I may just pass along this, not ERC regulation.
Please
It
pass
clearly
on.
talks about under which circumstances one can disconnect electricity.
Yes.
Not page number 74, my lord. It deals with prejudicial use of electricity.
70?
74, my lords. I'm sorry, this is 42 bar 2, my lords. That will be
Regulation number
my lord, 42.07.
42.07.
You know, there has to be a provisional assessment followed by a final assessment. A notice has. The lords will find it at page 87 at the bottom.
Provisional assessment order on account of prejudicial use of power is 42.07.
Yes, ma'am. You have to issue a provisional assessment for me, and only after I submit a response, and you have to clearly spell out what are these illegalities that I've committed. Not having an illegal building, my lord, running an unauthorized PG is not a ground. It has to be either I am paying a tariff which is much lower, or
Yes,
I am.
you appear takes notice for BESCOM. So the papers on it.
I have already said.
And also serve him on.
Yes,
So and
I'll
so
do.
is directed to take notice on behalf of BESCOM. And you please tell the court, what are the powers of the BESCOM to interfere in these kind of matters? Under which authority, whenever any local authority has any issue, that you are dealing with it. So which provision in the, which regulation permits you to do it, or any circulars or any law in that regard?
In normal course, when GBA authority is there, we are in consonance with the GBA authorities. Then once the rules and regulations of
all of
GBA
you,
is,
all of you are the instrumentalities of the state. That doesn't
Yes,
mean that
yes.
you will be helping each other just like that without a provision and law.
Not that like.
So you, now whenever somebody asks you a connection, you say you are bound by the regulation.
Yes.
When you have to disconnect, also you are bound by the regulation. That time again, then local authority, your connection with it and their connection with you, that can't be the procedure. So tomorrow you will be enlightening the court on this aspect.
Yes.
May I request for a stay, my lord, because I'm running a PG with 50 plus students. There is a threat of
I'll take it up.
Let them not take any
Don't
precipitate.
do anything till tomorrow. Instruct. So and so is directed to take notice on behalf of which respondent?
Respondent number 1 and 2.
Respondent number 1 and 2. So and so print his name. Then counsel the petition, serve the copy of the writ petition. List this matter in the first list. By the time the counsel for the respondent shall get specific instructions on how, without what is the source of power to the respondents, to the respondents to disconnect the power supply of the petitioner or interference with the power supply.
Let them not take any precipitated
And
action.
the respondent shall not precipitate the matter till tomorrow. List it in the first list, sir.
Operative portion of the order maybe, so that I can coordinate with the concerned office.
Why otherwise they'll not? You can tell that the court has appointed you, that's what, as a panel counsel, for that operative portion is, anyhow it will be uploaded by evening.
Yes.
Then number
Yes.
31,
Yes.
Ananda
List
K.
it in the first list tomorrow.
Appear for the petitioner. This is the writ petition filed by the defendant number 19. The application filed by the defendant number 19 seeking permission to file the return statement was rejected, saying that there is
Is a delay?
delay is 9 months. Your Worship.
Huh?
9 months.
Why 9 months delay?
But I am the
After 120 days, 9 months.
including 120 days. The notice, I filed the wakalat on
For 4 months is?
14/3/2025. I
4
filed.
months is 120 days.
Please, ma'am.
4 months is 120 days.
Please, ma'am.
Hmm.
I filed the wakalat on 14/3.
Another 5 months.
Please, ma'am.
Yes, please come. Then counsel for the petition submit, sir. Which suit? It's a commercial suit or regular suit?
Please, ma'am.
Commercial suit or regular suit?
Regular suit, Your Worship.
Then counsel for the petition submits that as the petition has failed to file the written statement within 120 days, the court has failed to take the written statement on record in view of the amended proviso to CPC. he has relied on a judgment of the coordinate bench of this court, wherein the coordinate, in so and so, wherein the coordinate bench has stayed the operation of the amended provision in that view of the matter, there shall be stay of all further proceedings.
Lord, Madam President, my consumption, notice may be dispensed with the respondent number 2 to 19. They are the co-dependents.
2 to 19 dispensed with at the risk of appellant.
Please.
Notice to 1 along with hand summons on the council appearing for the respondent number 1. 28th memo shall be filed July, or else the stay granted by this court stands vacated.
Oh, please.
Sidramaya MEP.
Yes.
Yes. My lord, petitioner is a purchaser of the property in a layout formed after conversion of the land.
What is the suit for?
Suit for partition suit was filed by the respondent 1 to 4 without making petition as a party to the proceedings, and collusive decree was obtained. It was not contested. Thereafter, the respondent 1 to 4 have filed execution by final decree proceedings. In final decree proceedings, when I came to know that my property is included in the partition suit, I have filed application for impleading in the final decree proceedings to contest and for deletion of my property in the partition suit in view of the sale deed executed by the respondent number 1 to 4. The trial court has rejected the application by coming to the conclusion that the parties who are in the original suit or decree in the preliminary decree are entitled to come on record only in the FDP, not the other parties. That is the finding given by the first trial court. 93 is the finding given.
You're the family member.
No, I am not a family member. I am purchaser of the property.
Hmm.
A layout was formed. Conversion order was
From whom?
from the family member.
When?
Oh, long back, my lord, in the 2012, I have purchased. My lord, developer has purchased in the year 1997. Even developer was also not made as party to the proceedings. Subsequently, from developer, I have purchased in the year 2012. Both developer is not made as party, and the 2022 I have purchased the site in the layout formed by the developer.
What is the response?
My lord, further proceedings, my lord, commissioner is appointed for demarcation. At any time, my lord.
Notice to the respondent, petition is permitted to take out hand summons and file a memo. When can you file?
Within 1 week.
This is matter. If the memo is filed by 20th of July, let's just matter on 21st.
Yes, please.
Action number 33, Manu Prabhakar Kulkarni for petitioner. As I'm appearing to the petitioner.
Lord, if I may request for a short passover, my lords, my colleague who is making submissions is on his legs in another court.
Passovers will not be called.
My lords, if it may be had tomorrow, my lords. There is urgency in the matter, my lords.
This is matter day after tomorrow.
Please.
Yes.
Action number 34. CH-19 Rao.
Where is he? Is there any interim order? This is matter in the month of September. No representation for the petitioner. Is 35.
Action number 35. Umesh MN.
Petitioner, please. That suit is filed for permanent.
Have you served papers on the caveator?
Yes, ma'am. I have served it.
Yes. Yes.
Suit is filed for permanent injunction, restraining the defendants from.
Any of the respondents?
Please, no? There are 4 respondents.
You appear for all the 4? Yes. Injunction, concurrent finding?
Injunction was granted by the trial court. That was disallowed by the first appellate court.
Please come to the judge.
My lord, may I request your lordship to, yes, my lord, may I request your lordship to kindly come to ink page number 93, my lord?
93.
93.
Wait, what is there at 93?
In 93 is the reasoning given by the trial court.
We will see the appellate court's order first. Please come to the appellate court's order.
Page number 30. my lord.
Let's please
Upon
come
hearing-
to page 18, paragraph number 9.
Whether the respondent plaintiff established a prima facie case and all those things.
Below that.
Page number 31, may I read, my lord? Point
Yes,
prima facie case.
yes.
The legal framework governing the grant of temporary injunction under Order 39 Rule 1 and 2 of the so and so was settled.
That you can
well-
skip,
well-
I think. You can come to 9.1.
Yes, no. The foundation of the respondent's case rested entirely upon a registered partition deed dated 4/1/2003. The respondent claimed that the said deed conferred upon him the right to perform pujas on 3 days of the alternative weeks. However, on a careful examination of the partition deed disclosed that the archakship rights are thereunder were conferred jointly upon the respondent and K.N. Sheshadri. The archakship rights was not exclusive to the respondent. Upon the demise of K.N. Sheshadri, his legal heirs being the appellants inherited and stepped into his shoes with respect to the joint archakship rights. The respondent therefore could not, on the basis of the partition deed alone, claim an exclusive or independent right to perform the pujas in the manner that excluded.
Between the plaintiff
I am
and the
not claiming exclusive right. My
No, what is the relationship between the plaintiff and the
brothers.
Let us look at your plaint once. Where is it?
Plaint, your lordship would find. I'm sorry, my lord. I have produced it at annexure B, my lord. Prayer, your lordship would find that in page number 48. Not claiming any exclusive right. Therefore, 48, my lord, is the prayer. Wherefore, this honorable court be pleased to pass a judgment and decree for permanent injunction, restraining the defendants from interfering or obstructing.
Wrong with numbering of these. After 47, there is 44 and the order of the trial court.
May I just pass on, my lord? I have the copy with me. May I pass on?
Take that.
This honorable court be pleased to pass a judgment and decree of permanent injunction, restraining the defendants from interfering or obstructing with the right of worship of the plaintiffs on 3 pujas of the alternative weeks in the Akayama temple and to grant cast of the suit.
According to you, your share is 3 pujas.
Only 3 pujas, alternative weeks. That was, in fact, being continued for more than several decades. And the learned First Appellate Court holds that I am seeking an exclusive right. That is patently incorrect. I'll further read the.
9.2.
More fundamentally and decisively, the respondent himself is a participant in the constitution of Sri Akayama Religious and Charitable Trust. I am not a party to it. By the registered trustee dated so and so. The trustee was a formal institutional, the instrument that exclusively vested the management, administration, and control of the Sri Akayama temple, including the appointment of checks and regulation of puja activities in the managing trustees and the board of trustees. The trust deed was a subsequent specific and the registered instrument that had the legal effect of creating a formal institutional framework for the governance of the temple, superseding any informal or general family arrangement that may have existed under the partition deed. Even the partition deed was a registered document. It was a fundamental practice that there were a later instrument specifically and expressly deals with the subject matter that was covered by an earlier instrument, and the later instrument prevails. The respondent, having voluntarily participated in the execution of the constitution of the trust, was bound by the trust deed by subjecting himself to the institutional authority of the trust. The respondent had effectively consented to the governance structure created by the trust deed. The respondent could not therefore seek to bypass the trust deed and assert an independent personal right to perform pujas as Pradhan Archak in derogation of the trust authority. The most critical consideration, however, was that the respondent had not challenged the trust deed in the present suit. The respondent had not prayed for declaration that the trust deed was void, fraudulent, inoperative, or that was liable to be cancelled.
What is this 9.5?
A right of managing the trustee of the trustee to manage the temple and appoint archaks for the performance of puja was exclusively recognized by the trustee. The respondent, being a signatory and participant in the trust, was bound by that arrangement. The respondent could not claim a right that was inconsistent with the trust deed without first obtaining a judicial declaration that the trust deed was void and or that it did not bind him. The present suit did not contain any such prayer. The trial court had no occasion to examine or adjudicate upon the validity of the trust deed. The amendment to trust deed was made by the defendant without even knowledge to me.
But the court observes that
that is patently incorrect. I'll place the trust deed, Miller. I'll place the trust deed and bring it to your lordship's kind notice that it was a voluntary act done by the defendant to affect my right.
It is not there now.
It is not there.
You have a copy? Page number 1 to 40. Anjan Kumar S.
Uh,
Shastri, who is
K.N.
he?
Sheshadri.
Dr. K.N. Sheshadri, you are?
I'm Chandrasekhar Shastri.
No, there
My,
are.
my name is, though my name is forthcoming,
Chandrasekhar Shastri at,
though my name is forthcoming, my signature is not there.
it is there.
No, Miller.
No, he had to challenge his team when he's not.
No, it is not there. Chandrasekhar.
Chandrasekhar Shastri signature is
Chandrasekhar.
there.
No, Miller, it is not my signature. It is not my
Who
signature.
inside now?
Miller, Anjan Kumar Shastri, K.N. Sheshadri. Only these two people. In page number.
Page 39, come to page 39.
Page 30. No, page 39.
Your signature is there.
No, no, by virtue of the amendment, they changed it. Your lordship would
What
find
is this? No,
41,
this-
Miller. I'm a party to the trustee, no doubt about it. They make an amendment to the trustee.
Let's read where it starts. Trust deed is dated. This is September 2008.
Yes, Miller.
You are a party to 6/9/2008.
I'm a party to the trustee, but by virtue of an amendment to the trustee, they make changes. I think page number 41.
Come to that amendment of the trustee.
Yes, Miller.
This is from
Parties
41
are Anjan Kumar, K.N. Sheshadri.
41 to 92. Please
Yes.
come to 92.
Though my name is there, Chandrasekhar Shastri, I have not subscribed my signature to this.
92.
No, not 92, Miller. Immediately after that.
No, he has written copy of your first page. Copy of the amended trustee deed 41 to 92, something you have written.
No, it is not. It is only, it runs to 4 pages, that's all. Either. 4 pages. Either.
Because there are so many properties and other schedule is there.
Only 4 pages.
Only 4 pages.
Third is Chandrasekhar Shastri.
My name is not there at all, Miller. Anjan Kumar Shastri and K.N. Sheshadri.
No.
No, though my name is shown in the deed, I have not subscribed my signature to this. Your lordship would find only 2 signatures are forthcoming. Anjan Kumar Shastri, Managing Trustee, K.N. Sheshadri, Trustee.
Say on that.
Say, private charitable. In the year 2003, there is a partition bill, it is admitted. They had filed an RSA before the Supreme Court admitted compromise petition has been entered. For each of us, there is no occasion for us to dispute the compromise deed or partition. It has been admitted, both of us. Whereas in this case, in this suit, where he has not challenged the amendment application or trust deed or compromise petition entered before.
He's not a party to that.
A party will.
Where is he? Where is you've taken signatures of everyone, but not his signature. How can you say that he's party to this?
He's a party.
Yes, please amended trust deed, please show his signature.
Where he had not challenged this one before the court.
What about challenge? The court gives a finding that being a party to that, you have not questioned it. Where is he a party? He's not a party. You unilaterally you deviate from the original trust deed, amend it as per your own whims and fancies. Obviously, it's binding on him. He doesn't have to challenge it.
He is now aged about 74 years.
Forget about it. First, you clarify this aspect to me.
Till today, he is participating in the temple activity. Till today, he is there. Whatever the received by the contributions to the temple, he daily is still and daily are sharing by the 3 of us, 2 of us. There is no difference. I am not disputing. Where the trial court granted the injunction, at that time also I have not input. He had been receiving the
So
whatever.
we'll restore trial court's injunction.
Let me, I am the Pradhan Archka. He is not able to function 10 to 3 p.m. for every
No,
day.
what is the injunction that's granted? Let us see.
Your lordship would find, I think page number 101, Miller. 101.
101.
The interim application number 1 filed by the so-and-so, by the plaintiff under order 39 rule 112 is allowed. The defendant bar opponent, their agents, service servants, or anybody claiming through them are hereby temporarily restrained by way of temporary injunction from interfering or obstructing the plaintiff from performing the 3 pujas on the alternative weeks of Akayamaya temple situated at so-and-so. I'm not seeking an exclusive right.
Daily activities is participating. I am not objecting. Let it may be continued.
like this.
Not like, let him whatever he is doing.
No, no, no. This has to be as per the trial code. No, my lord, because I'm aged.
In that case, no, in that case, what you can do is, don't allow him to participate every day, only 3 days you participate.
That's all. That is what I am seeking.
It applies to you also.
Yes,
You
my
can't
lord.
go
Yes,
every
ma'am.
day.
No, I'm
you
only
participate
seeking,
on
my
3 days.
prayer itself is for 3 days.
He is not able to make a fasting for daily.
Huh?
For temple daily activities, he is not able to do the fasting. And he is not able to, he is 74 years. Morning 10 to 3, he cannot be participated in that 3 by 6 only puja will be. In that only one person can be seated there. Others
My lord,
cannot be there.
that has been answered by the trial court.
Let him continue whatever the activities is there, where I am not objected before the trial court, when the extreme order is handled by the trial court. Let him continue with that prayer, with understanding.
So, what you want that trial court prayer to be restored.
But not
Trial
that
court order to be restored.
The trial court injunction order is there, I am not interfering with the activities of the plaintiff. I am not obstructing. This activity will be continued.
That is what,
In fact, may I request your lordship to kindly take
I
his
will
page
set
number two?
aside the, why is
Please.
arguments unnecessarily? I'll
No, no,
set
he
aside
said
separate
he's 74 years and in fact, court records that the defendants have contended that the plaintiff being more than 74 years, he is unable to perform the pujas and render services to the scheduled
Please
property.
come, I'm not going into
However-
all that. The
however, the
petition
plaintiff-
is agreed with the order. The petitioner plaintiff is agreed with the order passed in MA number 10 of 2026 dated 15 June 2026 by the Principal Senior Civil Judge and JMFC at Devanahalli, reversing the order passed by the, where is the TIA order?
Yeah, 104.
Order passed in I number 1 in OS number 453 of 2025 dated 7th April 2026. The petitioner herein has filed a suit seeking a judgment and decree for permanent injunction, restraining the defendants from interfering, obstructing with the right of worship of plaintiff on 3 pujas of the alternative weeks in the Akayamma temple, and to grant costs of the suit and for the other reliefs. Along with the suit, he has filed an IA seeking ad interim injunction. The trial court, by order dated 7th April 2026, has granted injunction as prayed for. While granting the injunction, the court has observed that the pamphlets produced by the defendants themselves published by the temple administration clearly indicate that late C.K. Sheshadri was functioning as an administrator, whereas the plaintiff has been sworn in as a main priest in the Sioux Scheduled Temple since 2009. The court has observed that the defendants themselves have produced the copies of the mark cards and degree certificates of defendant number 3. On careful of the same, it is on careful reading of the same, it is clear that the defendant number 3 completed his degree and postgraduate studies in the year 2018. Further, the defendants have admitted that even prior to the formation of the trust, their father, before that, defendants have also admitted in their written statement that the defendant number 3 started performing puja in the Sioux Scheduled Temple in the year 2016. However, the pamphlets relied upon by the defendants themselves indicate that the plaintiff has been functioning as a main priest of the Sioux Scheduled Temple. Further, the defendants have admitted that even prior to the formation of the trust, their father and the forefathers have been continuously performing pujas in the Sioux Scheduled Temple for more than 100 years. This admission supports a case of the plaintiff that he has been performing the puja in the temple. It is a contention that the defendant's contention is that plaintiff is more than 74 years of age, is unable to perform the pujas and render services to the temple. The court observes that the plaintiff has personally appeared before the court. Without assistance or upon observation, he appears to be hale and healthy and capable of performing puja. at least on alternative weeks. Denial of an opportunity would adversely affect his mental well-being and his religious beliefs. The court has come to the conclusion that the plaintiff has established a prima facie case and without going into the merits of the matter is entitled for injunction. And accordingly, restrain the defendants from obstructing the plaintiff from performing the 3 pujas of the alternative weeks in the temple. Agreed thereby, the matter was carried in appeal. The appellate court mainly had dismissed as allowed the appeal filed by the defendant, observing that
That the trustee is not challenging.
that the managing trustee, the right of the managing trustee to manage the temple and to appoint archakas for the performance of pujas was explicitly recognized by the trustee. The respondent, being a signatory and participant in the trust, was bound by that arrangement. The respondent could not claim a right that was inconsistent with the trust deed without first obtaining a judicial declaration that the trust deed was void or that it did not bind him. The present suit did not contain any such prayer, and the trial court has no occasion to examine or adjudicate upon validity of the trust deed. Hence, the court has held that there is a prima facie, the plaintiff has failed to establish a prima facie case for the grant of temporary injunction, and the trial court's conclusion is contrary. A conclusion to the contrary was erroneous, perverse, and contrary to the material on record. And further, when it comes to balance of convenience, the observation of physical health in court was not a substitute for a proper assessment of ritual capacity. And the trial court reasoning on this point was superficial and unsatisfactory. This is correct. This finding of the appellate court is correct. How can the trial court say that he is physically fit, he'll do?
Because that contention was taken, perhaps the court has done that exercise.
And the court has held that the finding of the court on the trial court on the said aspect is not correct. Then when it comes to irreparable loss, the court observed that the right claimed by the respondent was the right to perform puja. The respondent had not been denied access to the temple. The respondent retained the right to visit the temple, to offer prayers, and to participate in the activities of the temple in a subordinate capacity. The question of irreparable loss would not arise, and accordingly, the court had allowed the appeal. Agreed thereby, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that the findings of the court are contrary to the material on record. Court in its order has observed that the petitioner is a signatory to the amended trust deed, and being a member, being a part of the said, being a signatory to the said trust, amended trust deed, he cannot he cannot make submissions contrary to that. And apart from that, he has not questioned the said trust deed as not binding on them. In those circumstances, the plaintiff cannot submit contrary to the same, and accordingly, contrary to the same, and allowed the it is submitted that the trial court has rightly considered all the aspects and granted injunction, and the jurisdiction, the order that is passed by the court is contrary to is beyond the jurisdiction that is conferred on an appellate court while considering an application, while considering the order of the trial court granting injunction. It is submitted that as the petitioner is plaintiff is only seeking the, as per the earlier date, 3 days to do Archakatvam for three, what is it? 3
3 days in alternative weeks.
3 days in alternative, 3 days in alternative weeks. It is submitted, the order and appeal may be set aside. And the injunction that is granted by the trial court may be restored. When counsel appearing for the respondent defendant submits that the trial court is rightly, the appellate court has rightly held that the plaintiff has failed to question the amended trust deed. It is submitted that he has been
Actively participating daily.
he has been actively participating. At any point of time, there was no obstruction for him in participating in the rituals of the temple.
Equally divided end of the day.
Huh?
Equally divided by the end of the day.
Equally?
Divided whatever the contribution received for the day. Equally divided by the petitioners.
There is no such thing.
How can I decide that here?
We are understanding on that basis it's a earlier.
Whatever it works, because it is his IA that is coming up.
That also he has not questioned.
If he is not, you file an IA before the trial court. Trial court will decide. It is submitted that the order passed by the appellate court is a well-considered one and no interference is called for. Next part. Having got the counsels on either side, produce a material on record. The petitioner, plaintiff has come before the court basing on an earlier trust deed and the rights that have accrued in favor of the parties. According to the defendant, as per the amended trust deed, the petitioner is not entitled for the relief as sought for. The trial court has rightly considered and at an interlocutory stage, considering the prima facie case balance of convenience and irreparable loss, has rightly granted injunction as the plaintiff could prima facie make out the 3 ingredients. When it comes to the appellate court appears to have more relied upon the amended trust deed as rightly argued by the land counsel for the petitioner in that and this court has perused the amended trust deed. Though his name finds place, he was not a signatory to the amended trust deed. In that case, question of petitioner questioning the said trust deed and other aspects at this stage, the court ought not to have gone into. And because there is another view possible, the appellate court ought not to have interfered with the order of injunction that is granted by the court. With regard to the rights of the parties, what is their entitlement will eventually be decided by the court in the pending suit. And at this juncture, the continuation of the earlier arrangement is in the interest of both the parties, and the trial court has rightly granted injunction, and the appellate court, without any basis, has interfered with the same. Hence, this court is passing the following order. The order passed by the appellate court in MA number 10 of 2026 dated so and so is set aside. Accordingly, the writ petition is allowed.
Great.
But the plaintiff may be directed. Only the plaintiff can perform the puja. Under him, the daughter is daughter should not be interfered.
They can assist. What is wrong with that?
Not assisting. When he is holding the hundi to not to contribute any persons to the hundi.
It is made clear that as per the original trust deed, the original trust deed till further adjudication will bind both the parties.
Please.
And all the rituals, and other aspects shall be governed by the said compromise or trust deed. Compromise deed oblique partition deed. Partition deed. Yes.
The plaintiff other should not interfere. Under the plaintiff other should not interfere.
No, that's what. If that gives plaintiff, that is violation of the the injunction order.
Serial number 36. Hegde Ramnath Ganapati for petitioner.
Appear for the petitioner in this
Yes.
case. Not the petitioners or the defendants in the trial court. The application filed by the petitioners under Art 7 Rule 11.
Come to the application.
Yes.
Where is it?
Page 25, my lord. The affidavit I will read. For the reasons stated in the please to reject the plaint as the same has.
Come to page 26, affidavit.
Yes. Para 4. I submit that the suit of the plaintiff is absolutely barred by law of limitation and also the suit has no cause of action. In this regard, in our written statement, we are specifically pleaded and also prayed for frame the issue and also for treat the same as preliminary issue. The Honorable Court framed issue number 3 on limitation but not framed the issue about cause of action. Hence, I am filing this application praying for dismiss the suit as the same has no cause of action and also barred by law of limitation. I further submit that by reading of the plaint governments.
In this para, they say that because they have not framed an issue, that's why they are filing Order 7, Rule 11. If they have not framed, you can ask for recasting of issues.
Affidavit is not happily worded, I quite agree. But the point of law is, in the if the plaint itself, it is.
Suit is for specific performance.
Specific performance, not plaint and the document on which the plaint relies, that is the agreement of sale, itself provides a mechanism. The sale deed is to.
Agreement of sale.
Pardon me.
Where is agreement of sale?
Agreement is, I have produced at the end.
Page number?
Agreement is annexure E. But in the agreement, there is a specific mechanism. If I fail to comply with the agreement, they have a liberty to deposit the amount in the court within 6 months. They will have to wait till 6 months. If I fail to execute the sale deed.
When is the date of agreement?
Date of agreement is 3/2/16. 3/2/2016. Now the suit is now filed in 2023. One thing. Now thereafterwards, another development has taken place after 16. I have sold one of the property out of the three properties. In 2018, I have sold one of the property to the third defendant. There also they did not object or not taken any action till 23. Now two things. Forget about my defense and all that. No question of preliminary issue and all that. If the plaint itself is taken as a whole, in the plaint also, in para 4, they say that 6 months is the time limit.
Please come to the impugned order.
Impugned order, page 53, 5626 is the date of the order. It is typed in the order sheet itself. IA number 4 is filed by defendant number 1 and 2 under Order 7 Rule 11A(d) of CPC seeking rejection of the plaint on the ground that there is no cause of action to the suit and that the suit of the plaintiff is barred by law of limitation. In the affidavit filed in support, so it has sworn to the fact that the suit of the plaintiff is barred by law of limitation. It is stated that the agreement of sale is dated 3/2/16 and the time stipulated for performance of the contract was 6 months. Thus, it is contended that the suit is hit by Article 54 of the Limitation Act. Further, it is stated that there is no question of demand for execution of the early registered sale deed, and as such, there is no cause of action to the suit. On these grounds and such others, it is prayed for allowing the application. Per contra, the plaintiff has filed objection to the application, contending that the defendants have failed to perform their part of the contract and they have refused to perform their part of the contract in the year 2023, for which he has got issued legal notice to the defendants. On these grounds and such others.
Counsel for the petitioner submits that the suit is barred by limitation on the face of it. Looking at the pleadings itself, the defendant could make out a case that the suit is barred by limitation. It is submitted that in the year 2016, on 3/2/2016, an agreement of sale was executed. In the said agreement, within 6 months, if the petitioner fails to, if the defendant fails to pay fails to execute a sale date, the plaintiff has to deposit the amount within the court. That clearly shows that it is not clearly shows that limitation, and that expired in the year 2016 in the month of August
2023.
The month of August 2016 itself, the 6 months time elapsed. And in the year 2018, one of the property the plaintiff has sold, and the suit came to be filed in the year 2023. This aspect was not considered by the court. Considering the submission, they shall be stay of all further proceedings pursuant to so and so. Notice to the respondents, hand summons. Memo shall be filed by 28, or else the stay granted by this court stands.
57 for orders matter Yadunandanan.
It appears writ petition lies.
Memo, the office has raised an objection with regard to maintainability, and counsel the petition submits that they were permitted to withdraw the writ petition, withdraw this CRP, and may be given liberty to file the writ petition. Considering the submission of the learned counsel, the CRP is dismissed as withdrawn with the liberty to file a appropriate application within 2 weeks from the date of receipt of the copy of the order. The registry is directed to return all the documents by keeping this oath.
Cell number 38, R. Shashidhara.
Petitioner in this case.
Unserved, refused.
Refused.
Notice to R1 returned as refused. Amounts to deemed service of notice. Extension of time filed. What is this extension of time?
While granting interim order, this honorable court dated 25/3/2026. I was directed to pay deposit 1 lakh. Plus order passed on 25/3/26. They directed me to deposit and within 28/3/26. But I could not able to get the certified copy of the order. Only
Want certificate copy?
Yes,
For staying the proceedings, online copy is sufficient. For paying the
no,
money.
the
no
online
certificate.
copy also not uploaded, since I instructed the party, but he is an
You were there in
village.
the court.
Yes,
You were there in the court.
I'm specifically instructed the party to deposit within 1 lakh within 28/3. But party approached my counterpart. My counterpart asked him to get the certified copy. There is some miscommunication. I could not able to deposit. Within 1 week, I will deposit the 1 lakh. The execution, totally, they filed recovery of 1,94,000. Within the 4 weeks, within two times, I will deposit the entire amount.
Entire amount you deposit, I will list this matter next week. Stay till such time. If not, I will.
Entire amount.
Whatever is the order.
1 lakh, 1 lakh.
Whatever it is.
Please.
It is an IA is file seeking extension of the time as stipulated under in the order dated 25/3/2026. Learned counsel submits that they could not get the copy on time, and there was some communication between the party and the advocate. Hence, he seeks time, considering the request of the counsel for the petitioner. The order, the time that is granted by the court by order dated 25/3/2026 is extended till 21st of July. By 21st of July, as per the order dated 25/3/2026, if the amount is not paid, the interim order granted by this court dated 25/3/2026 stands vacated, and no further application shall be allowed. And on this ground, the writ petition shall stand dismissed.
Order copy may be
Today itself you will get.
Please.
Disposed of.
Cell number 39,
Petitioner.
H.N. Vasudevan.
Also, the petitioner is the plaintiff in the matter who has filed a suit for permanent injunction with respect to
Non-filing of copy served. Copy
served.
Served, yes. All the respondents are served.
Yes, Your Lordship.
You appear for all the respondents?
1 to 4.
How many are there?
5, Your Lordship.
Who is the fifth respondent?
Respondent number 5 is the developer of the property from whom I have purchased the property.
Is it necessary or not?
No, Your Lordship. No.
Necessary party because he is vendor. He has purchased the property from that developer.
No, for this application.
Not necessary, Your Lordship.
Then you file a memo.
Please.
Give a memo.
I'll submit.
So that because now I'm hearing, I'll hear it finally. That's why I'm.
Please, Your Lordship.
Memo
Please.
is filed seeking dispensation of notice to
Respondent number 5.
respondent number 5, as he is not a necessary party to this application. Accordingly, memo is taken on record and notice to respondent number 5 is dispensed with. Yes.
Lordship, the petitioner is the plaintiff in the matter who filed a suit for permanent injunction with respect to the suit schedule property, which is at page number 19A. All the piece and parcel of the property bearing site number 67 in Maple Meadows layout, which layout is formed in property number 47 and 48. I have purchased the property from the developer, who is respondent number 5, who is the owner of property number 48. The defendants number 1 to 4.
What is meant by property number?
Survey number, Your Lordship. Survey number, Maple Meadows layout,
What is that you purchased? What is that?
a site, Your Lordship. In this layout called Maple Meadows layout, there are over 199 sites.
You have purchased
In
one
that,
site.
I have purchased one site, which is site number 67, Your Lordship.
Admeasuring?
Site number?
Admeasuring?
Admeasuring 2,400 square feet, Your Lordship, in 2013. After purchase, the defendant numbers, respondent numbers 1 to 4 are the owners of survey number 47. I have purchased site number 67, which falls in survey number 48 in this layout called Maple Meadows layout. After purchase of the property in 2013, Your Lordship, I have, Khata has been transferred to my name. I have been paying tax on the property. I'm a senior citizen, Your Lordship. 10 years later, in 2023, the respondents number 1 to 4 in September 2023, the respondent numbers 1 to 4 come into my property and start digging with the JCB and other people start digging into my property. Neighbors call me, I run and come, and they say they are the owners of survey number 47, that this is their property, it is not yours. I purchased the property in 2013, Your Lordship. This is happening in 2023, which forced me to approach the trial court, and I filed a suit for permanent injunction. Along with my suit for permanent injunction, I filed an IA for temporary injunction. My IA for temporary injunction is at page number 100, Your Lordship. Your Lordship may kindly see. At page number 100, IA number 1. At page number 100 and at page number 100, and if Your Lordship may kindly see, at page number 100 is IA number 1, wherein my prayer was to restrain the respondents from trespassing or creating any charge over the suit schedule property.
Where is the prayer?
At 46, Your Lordship. Sorry, at page number 101. Page number 101 on top, Your Lordship. It's for restraining them from trespassing into the property. The trial court held, Your Lordship, as I had rightfully said in my plaint, that they have already entered the property. The trial court said, since they are already in the property, we cannot pass an order. We cannot pass an order restraining them from entering the property.
According to you, they have already taken possession of.
No, they entered into my property, started digging, Your Lordship. Possession is with me. Thereafter, Your Lordship, IA number 1 emergent notice came to be issued. I thereafter filed IA number 2, which is at page number 106, Your Lordship. At page number 106, I filed IA number 2. Lordship will find the prayer at 107. At 170 on top, Your Lordship. To restrain them from carrying out any further construction on the suit schedule property. The trial court heard the matter, allowed my IA number 2, and restrained them from carrying on any more activities in my property. They filed IA number 3 for vacate under Order 39 Rule 4. Lordship, all the 3 IAs, IA 1, 2, and 3 were heard, and the trial court passed an order to maintain status quo, neither for them nor for me, because I purchased this property in 2013. They are saying this property is not in survey number 48, which as per my sale deed, it's in survey number 47. Trial court said we'll decide it. For now, stop everything, status quo to be maintained. They have, Lordship may kindly see that order at page number 128, Your Lordship. I will only take, Your Lordship, the relevant paragraphs in that order, Your Lordship. Your Lordship may kindly see at page number 140, page number 140, Your Lordship. Paragraph 18, Your Lordship. At page number 140, paragraph 18. Now it is the claim of the plaintiff that the plaintiff has purchased the suit schedule property from defendant number 1 under the registered sale deed, and after purchase of the suit schedule property, the plaintiff has been in possession of the suit schedule property. On the other hand, the defendants have denied the possession of the plaintiff over the suit schedule property and contended that the suit schedule property is not carved out in survey number 47. The plaintiff, to knock off the second defendant property, has filed the suit, and the plaintiff does not have any title of interest over site number 67 formed in survey number 47. On a careful perusal of para 3 of the written statement, the defendants have stated that Maple Meadows layout have been formed in survey number 47. They are agreeing. There are 199 sites. There's only one site number 67, which is mine. 47, 48. Further in para 4, they have stated that the suit scheduled property, that is site number 67, is formed in survey number 48/1. It is their own submission in the written statement, Your Lordship. Then what right do they have to seek injunction against me, to seek any order against me? Further, by defendant number 1 may be true and correct. On careful perusal of the schedule mentioned in the plaintiff, sale deed dated 24/10/2013, it reveals that the defendant number 1 has executed the said sale deed in favor of the plaintiff in respect of property bearing site number 67, formed in survey number 48/1, situated at so-and-so village. Last, Your Lordship, on page number 142 towards the end, 142 towards the end. Hence, to ascertain that whether the site number 67 of the plaintiff is carved out in survey number 47 or 48, and who it is in possession, it needs full-fledged trial. Therefore, if the status quo order is granted, no prejudice will be caused to both the parties. They challenged that before the first appellate court, Your Lordship, and the first appellate court set aside this order, a status quo order, Your Lordship, which is at page number 22, Your Lordship.
Page number?
22, Your Lordship. If Your Lordship may kindly see page number 26, Your Lordship. Page number 26, para 4. I'm sorry, page number 26, sixth line from down, Your Lordship.
So these are all reiteration of the facts.
Reiteration of the facts, yes. I will take Your Lordships through. Paragraph 14. Yeah, at paragraph 30, at page 35.
Then come to 15.
Yes, Your Lordship.
The rival contention.
From the rival contention of the parties, it is quite clear that the plaintiff, claiming as owner and possession of site number 67, carved out in survey number 48, has filed the above suit alleging that his site number 67 is formed in both survey number 47 and 48, but the plaintiff has not produced any document to show that a common layout is formed in both survey. It is admitted by the defendant in the written statement that Maple Meadows layout is formed in survey number 47 and 48. Further, that my site number 67 is in plot number 48. Admittedly, the vendor is the owner of land with survey number 48, but not survey number 47. When such be the case, the plaintiff cannot claim over the site number 67, which is formed in survey number 47. There is, Lordship, there is only one site number 67, sale deed to which I hold. They have no sale deed with respect to site number 67. Taxpayer of 67 is by me.
Please continue. We'll complete.
Yes, Your Honor. Moreover, the sale deed dated so-and-so reflects survey number 48 of so-and-so village. But plaintiff is claiming his site property to that of site number 67, carved out in survey number 47 of the same village.
This is that it is in 48.
48, my sale deed is 48. He himself, in the written statement, they are saying.
What is this? But the plaintiff is claiming.
Yes, Your Lordship, that is where the mistake. That is where the error. That is the error.
Here in the plain schedule, he has inserted even survey number 47 to correlate. I am the owner of second.
Yes, we'll continue. Yes.
To prima facie convince the court with regard to claim of possession over the suit schedule property, the plaintiff respondent number 1 has to prove his possession based on the flow of title over the suit schedule property. The appellant's defendant number 2 to 5 have denied the claim of the plaintiff. On considering the materials available before this court, it is quite clear that the plaintiff has failed to make out prima facie case of possession over the suit schedule property based on his title deed. The learned trial judge, while considering materials placed before the court, has wrongly opined that it is necessary in order to maintain status quo in respect of nature and possession of the suit schedule property till rights of parties are determined and to preserve the property in existing status.
I have seen this. Please come to the plane.
Sorry, Your Lordship.
Yes, I've seen the order.
Yes, Your Lordship.
Come to the plane.
Come to the yes, Your Lordship.
Page number.
Lordship, the plaint is at page number 84.
Bearing site number 67 in Maple Meadows layout formed in property number 47 and 48 so and so.
Yes, Your Lordship. Maple Meadows layout is formed in 47 and 48.
Then when it comes to your case, where is the specific pleading with regard to only survey number 48?
But Lordship, I am only with respect to my site number 67.
That's what your site, where is that? Where is the pleading?
Paragraph 5.
Yes.
The suit schedule property, may I read Your Lordship, paragraph? The suit schedule property is represented to be formed in survey number 48/1 by defendant number 1, who is respondent number 5, Your Lordship. The plaintiff has purchased the suit schedule property from so-and-so, who's also the developer of Maple Meadows layout in survey number 47 and 48/1. That's the layout form. The defendant number one, who had represented the suit schedule property as formed in property bearing survey number 48/1, has executed sale deed in favor of plaintiff herein by sale deed dated 24/10/2013, registered document number so and so, and stored in the office of Registrar Shivajinagar. The certified copy of sale deed so and so is produced herewith. Now, if I may take your lordship through the written statement, which is at page number 91.
Then come to the schedule of the property.
Schedule, yes, your lordship. It's at page number 89, your lordship, page number 89.
Then why do you say that in property in number 47 and 45?
47 and 48.
8.
My lordship, site number 67 in Maple Meadows layout, which is formed in survey number 47 and 48. Maple Meadows layout is formed in survey number 47. It's a layout, your lordship, of 199 plot. I'll take your lordship through that. Your lordship, may kindly see the written statement, your lordship. At page number 91, your lordship. The first paragraph, your lordship. The suit filed by the plaintiff seeking for relief of permanent prohibited injunction restraining the defendants and their family and others from alienating, disposing or selling the suit schedule property, and also restraining the defendants from interfering possession of plaintiff over the suit schedule property is frivolous, vexatious, untenable in the eyes of law. The suit itself is not maintainable. The plaintiff is trying to correlate property belonging to defendant number 2, who is the owner of land bearing survey number 47, and he has converted as sites in survey number 47, totally 133 sites. He is agreeing to the fact that there are sites in both 47 and 48. Next para, your lordship, at paragraph number 3.
Oh, you read para number 2.
I'm sorry, your lordship.
I was looking at para 1.
I'm sorry, your lordship. Now, your lordship, we see paragraph number 3, your lordship.
No, we'll read. I'll complete reading this para 2.
Which paragraph? Sorry, your lordship.
Para 2.
Para. Without prejudice to the above contention, what is stated by plaintiff in para 3 of the plaint with regard to his claim that he is the absolute owner of site number 67 in Maple Meadows layout formed in survey number 47 and 48 of so-and-so village, Kannur Gram Panchayat, the Obli, Bangalore East Taluk, measuring 2,400 square feet.
Survey number 42 belongs to whom?
47 and 48. 47
belongs
to them. 48 belongs to the developer from whom I purchased the property, who is respondent number 5.
His vendor's title, in his title, if your lordship see, matter will be here. Because their vendor, he has purchased in survey number 48. His predecessor in title, he purchased the property only in survey number 48. Nothing else happened. The sale deed of his predecessor in title. They are claiming title in respect of survey number 48.
Now also that's what they're doing.
Now also here 48, that is also in the survey
But
number.
that is not under challenge here, your lordship. Here is respect to my site number 67.
But in the plain schedule, he has included my survey number 47.
No, that is Maple Meadows layout, which is formed in 47 and 48.
No, that will clarify. That I'll clarify.
Layout, that is my property. I have developed the property. I have not sold it to anybody.
Now,
And
we
his
will
claim-
say that status quo pertaining to the survey number 47, 48, plot number, that what is property or what is the number called?
Site number 67.
Site number 67. That will come.
48.
Yes.
48. Another one more thing.
My lordship, I may be permitted to complete just 2 more paragraphs in the written statement, if I may permit it to. Just 2 more paragraphs, and then paragraph 3, your lordship. What is stated in para 4 of the plain that Maple Meadows layout was formed in survey number 47 and 48 may be correct. But the alleged survey number 60, site number 67 of survey number 47 is not within the
It is
boundary.
nobody's case. It is not your case also.
No, my lordship. Next slide. But it is coming in survey number 48. The play. So he's accepting the fact that there is my lordship, there is no other site number 67 except mine. Next, that is my contention, your lordship. There's only my site number 67 which I purchased in 2013. Next paragraph, your lordship. Next paragraph. Only 4 lines I will read from paragraph 4. What is stated in para 5 of the plain that suit schedule property that is site number 67 is formed in survey number 48/1 by defendant number 1 may be true and correct. There is only one site number 67, your lordship, along with their objections that they filed. They filed objections to this matter, your lordship. They are at page number 26. They have produced a layout map at page number 26 of their objections, your lordship.
Where are the objections?
At page number 26, your lordship.
Page number?
26 of their objections, your lordship, that they filed in the matter. There is only one site number 67, which is here, your lordship.
Let's see.
67, your lordship, below, last column below here, your lordship. third
Yes.
above, 67. There's only 167 in 199 sites, which is mine, which I purchased. They are saying it is, does not fall here, does not fall there. That is why the Honorable Trial Court said, where it falls, we will see. But for now, let there be a status quo to decide, which is what the First Appellate Court reversed. In spite of the fact that they have undertaken and said, yes, they are the owners of site number 67. Yes, site number falls in 48/1. Yes, they have a taxpayer receipt. Everything is put to that. We have.
Yes.
When you see the plain governments, where the plaintiff himself has won, then he has purchased the site in survey number 48/1 from this vendor. 48/1. His claim is restricted only for 48/1. It is an admitted fact that I am the owner of both 47 as well as 48/1. I am the owner and the developer. I have developed.
In respect of 40?
48, 47 and 48. I am the owner of both the site survey number, but a portion of this 48/1 was purchased by the petitioner's vendor as per the sale deed dated.
Now, when you are not claiming.
7/3/2007. 7/3/2007.
One minute.
Yes.
When you are not claiming 48/1 or site number 67.
67 is mine because I have not sold it to him. If I were to be a developer.
No, when you say it is in 48/1, then that is not your site.
48/1.
Just now he has read the written statement. In the written statement, you have said that if it is in 48.1, he may be a owner, it may be correct.
That I will not deny. One minute. That is the reason exactly. I am taking my statement of objection to the main petition. And kindly see the statement of his vendor. Statement at page 65.
Page?
65. Connection of the T. The petitioner's vendor is one Mr. Sahu Stevens, correct?
Yes.
So, and kindly see the schedule at 71. 71. All the piece and parcel of dry land bearing survey number 48/1 situated at Anagura Kollali, Bangalore, measuring to an extent of 2 acres. His vendor, that is Sahu Stevens, he had ownership in survey number 48/1, measuring to an extent of 2 acres. That we are not nothing to do his 48/1. For the remaining extent of land, he has no right. The larger extent of land. I have found layout. I have sold the property to many people. I have retained some for my own benefit, for benefit of my friend. I am not disputing that. But now, the mistake, what has been done by the plaintiff is, he is trying to correlate his non-existent site, which he has purchased from his vendor, Mr. Sahu Stevens. And
No, please tell the court. Please tell the court.
And schedule note.
No.
Yes.
The 67 you sold to whom?
67 is mine. Same it. 66 and 67 belongs to me.
No.
58. 68 sale deed, David. Kindly see the sale deed, which I have written that.
Plot number 67.
Page 45.
Are you referring to plot number 67?
Yes.
No, your lordship, 67 is not there. They are referring to.
Let's see. Page number.
Page number 50. 53.
Yes. Site number 68.
53.
Yes.
Site number 68.
We are referring to 67. Where is 67?
I have not sold it to anybody.
Then it must be with you.
So, yes, that is what I am telling. When I am not his vendor, I must sell the 67, not somebody else. If his vendor has no right over 67, where is the question of selling my property? There is a law created because he number 47 and 48 are adjacent sets. Adjacent. Now, against his vendor, their vendor, they have filed a suit against all purchases. That is in suit number, kindly see. I have produced the plaint also at page 73 onwards.
I'll hear this matter. This is
73.
matter, the first case tomorrow.
Tomorrow.
Continuation it should be there. Otherwise, again I have to, day after tomorrow is the first case.
Lordship, last date.
I will come at 2:30.
Tomorrow.
Tomorrow.
Is tomorrow 2:30? Yes.
Cell number 40. Cell number 40, H.N. Vasudevan.
Yes.
I have not collected the hand summons, but there is an information, I will inform the council
Where
appeal
is the
file
memo?
board.
I will file the memo.
Memo has not been filed. In fact, the postal covers, everything has been provided long back itself, so it's not reflecting. Postal covers, everything has been provided. There is another 2 objections that has been complied with already. Needful and be done. The matter was referred to Lok Adalat day before yesterday. So it did not settle. It has been adjourned to 27th of July. In fact, there is information that has passed on to council appeal in the trial court. Even for both
This
the
is
parties.
matter on the 5th of August. Yes.
Cell number 41. Shekhar L.S. for petitioner. Awaiting notice.
Yes.
And summons I have returned. I was told that their parties have received the
List after service of notice. Next,
date may be given, my lord witness.
on 12th of August.
Cell number 42.
Await service, list on 12th. Yes, 42.
42.
Yes, madam.
K.G. Sadashivaya.
I've been directed to serve the copies on the other side. Right.
What is the order impugned?
Let me kindly appreciate that. After, let me, sir.
No, he's saying on the maintainability, let me hear him. What is the, what is this?
Appointing the commissioner.
Huh?
Appointing the commissioner.
Why it is not? Huh?
Final decree proceedings, commissioner has been appointed. That has been questioned before this
Why it
court.
cannot be questioned? Huh?
First, the profit has to be and development has to be decided and then the commission.
You're saying that maintainability of this wet petition. Why it is not maintainable?
This honorable board was
Huh.
ordered in earlier petition.
But there-
That's on the merits of the matter. He can file a writ petition against that order or not. Then he can, let him argue then. In that case, you will.
First, it is to be decided, then the commission needs to be appointed.
Law, you will tell the court once your turn comes. Let him argue on the merits of the matter.
After hearing for some time, this honorable court was pleased to grant an interim order and directed me to, pleadings have been produced before this court. Now, my lord, I am placing the materials before this honorable court. In addition to this, one of the respondent is not
No,
served.
without all that,
Yes,
please
sir.
tell me what are the facts.
Yes, sir. One of the
Please come to the
respondent-
impugned order. Then we will go to the other aspects.
Yes, one of the respondent is not served. Thereby, my
Number
lord,
8 filed with, first of all, whether their presence or not necessary or not, I'll decide.
Yes.
Number 8 filed by the petitioner is hereby allowed. The ADLR is hereby appointed as court commissioner for carrying out survey demarcating. What is wrong with this order?
yes, madam. Let me kindly appreciate, in the order passed by the trial court, is the question before this, para 10 may kindly be looked into. The contention of the respondent with regard to 75% of the social properties being subject matter of the litigation in LP, as SLP number so and so, so and so. The appointment of commissioner for demarcating the land and submitting to the feasibility of the property so and so. In so far the aforesaid application is rejected, then the above wait for disposal of the
Yes.
disposal of so and so.
Yes.
Let me kindly appreciate, the order of the Supreme Court is already completed, cleared, and concluded.
What
And-
concluded? Take that.
May give the copy of the SLP application came to be filed before the Honorable Supreme Court, that came to be dismissed. Now, my lord, my learned friend said that the trial court said that, my lord, it is still pending
until the disposal, we cannot pay it. That is the reasons. Please, let me say. Please. I produced the copy of that, copy was produced before the trial court.
You are agreed with the order passed by the court where it has allowed the appointment of court commissioner.
I'm not, Malad, I'm not opposing the.
Then what are you opposing?
Malad, for this reason, Malad, this is the order passed by this honorable court previously directing the trial court to take note of all the amendments and improvements made by the petitioner has to be looked into before at the time of appointing. Otherwise, Malad, I have no objection at all.
So what do you want the court to do now?
No, my lord, the trial court has to consider as per the direction issued by this honorable court. Previous order may kindly
What
be
is,
looked into.
please come to that order.
Please, ma'am.
Come to the order.
Yes, ma'am. That is order at Annex A, my lord. Previous order, my lord.
I'm looking at it.
Previous order, my lord.
Page number?
Yes, my lord, I have produced before this court. Please, let me.
Let him.
Please, my lord, Annex A may kindly be looked into. Page 76, my lord.
Yes.
The impugned order passed by the learned senior civil judge James Magdi, so and so, to the extent of rejecting the contention of the petitioner with regard to the improvements made by deceased defendant number 1 by investing his hard-earned money is hereby set aside. The petitioners are permitted to produce such documents to such.
Where did you ask the trial court to do all this?
My lord, thereby, my lord, after hearing for some time, I have been directed to produce the papers.
Take that. Where did you say so?
My lord, in the trial court, an application came to be filed before the trial court. The affidavit has to be filed before the trial court.
Page number.
And cross-examined was also by the parties. The impugned order may kindly be looked into, my lord. In that order, my lord, that page 168, my lord. The previous order passed by the trial court, my lord.
Why are we looking at the previous order passed by the trial court?
There was a specific direction issued to the trial court to look into the matter.
This court?
Yes, my lord.
That I have seen already.
No, my lord. Previously, my lord.
Singh Arul's order.
Let me kindly appreciate the application which has been filed to continue, consider the facts and circumstances under which the improvements have been made that came to be rejected by the trial court. That has been set aside by this court.
I understood all that. I have asked you one simple question.
Yes, ma'am.
After that, when an application is filed, seeking appointment of a commissioner,
yes,
who filed the application? They filed the application.
Yes.
Then you must have filed your objections to that.
Yes, ma'am.
In the objections, have you stated so? All this has to be looked into.
Yes, ma'am. That has
Where
to be
is
looked
that?
into.
That you please show.
The
That is not the order, that is your objections.
Yes, let me kindly appreciate.
If advocates are ready and straight away point out to the relevant, we can dispose of the matters fast without waiting like this. Where are the objections?
Yes, this is the application which was filed at the writ petition itself, my lord, at page 54. In that, my lord, page 64, I file objections.
In your objections, where did you say about that this has to be considered, that you point out?
Yes, madam. So let me kindly appreciate the first objections is not. There are several items has been narrated in the objections itself, because seven sites which have been included in the FDP proceedings, in which, my lord, the sum of the party has filed a separate suit before the court, and which he wanted to say that he has to be declaration right before the trial court. In which, my lord, that is one aspect. And the other aspect is, my lord, we have clearly stated in para 2 of the objections. My lord, it is submitted that when Timmananjaya has disputed the title of the properties.
No, that is not relevant. You are only on the point
No,
that earlier orders of the court were not considered. In which paragraph you said so? About the order of Justice Pradeep Singh Aror?
Yes.
In your objections, that I only asked you. If it is there, you point out. If it is not there, you can tell the court it is not there.
That is not at all considered, my lord. Only.
Where have you stated? In your objections, paragraph number.
In this matter, my lord, because the matter was already filed.
I think I'm not able to, make you understand what is my question is.
Because already objections came to be filed before the trial court. It was pending consideration.
Just 1 minute. I'll make myself very clear.
Yes.
I am asking you, after the matter is, now he has filed an application
Yes.
for appointment of please wait, listen to the court.
Yes, ma'am. Yes, ma'am.
You have filed an application for appointment of advocate commissioner.
Yes,
You filed your objections.
yes,
Court has allowed the IA. Now
Yes.
it is your objection that the earlier order of this court was not considered. I asked you a simple question.
Yes.
In your objections, where have you stated about the order passed by the
Pruma.
earlier branch?
Pruma.
Did you say so? Where is it?
You'll ask me kindly appreciate, my lord. The application came to be filed long ago during the pendency of the writ petition itself. We filed objections before the trial court during the pendency of the writ petition itself.
At least in your
Thereby,
arguments you said so?
thereby, in the writ petition as stated, my lord, that application has not been considered by the trial court.
This is matter in the month of September.
Cell number 43. Within AM.
But the interim order to be extended, my lord.
I'll not extend the interim order because I'm not convinced. Yes. 43.
Cell number 43, Nitin AM.
Non-compliance of office objections.
My lord, it has been complied with.
Why this council submission?
My lord, it is regarding the preamble portion, my lord. It is regarding the first objection, my lord, that preamble portion of Annexure D to be filed. Annexure D is a part and parcel of the entire order sheet, my lord. Therefore, we could not file it separately, my lord. My lord, if I may make a submission, my lord.
There is no preamble portion to Annexure D.
Yes,
As
my
it is a
lord.
part of entire sheet.
Yes, my lord.
Post WPPT for the court regarding non-compliance office along with council submission.
Yes.
Where is this Annexure D page number?
Page number 43, my lords.
What is the preamble? This is not 33.
My lords.
Annexure D is at
43, my lords. Page number 43, my lords, Annexure D.
Yes.
My lords.
Which order you are questioning?
3/6/2026, my lord, the bottom one.
Goes with the plain finance, police protection issue notice.
My lords, if
What is this order?
my lords, I am the plaintiff before the trial court, my lord.
This objection. Objections are overruled. Yes.
I had filed a suit seeking permanent injunction, my lord. Along with the suit, I had also filed an IA seeking temporary injunction, which came to be allowed. My lord. Subsequent to that, the plaintiff has not been able to be in the possession of the property, my lord. Therefore, we had filed an application, that is IA number 2 of 2025, my lords, seeking the assistance of police, my lord, to implement the temporary injunction. However, the trial court was of the view that notice is to be issued to the defendants. Accordingly, notice was issued. All the defendants were being placed ex parte. And then the matter came to be posted for hearing on IA number 2 of 2025, my lord. As the interference has been in continuance, my lords, We had advanced the matter, my lords, and on 3/6/2026, my lords, it has been recorded in the order sheet as counsel for the plaintiff filed IA number 2. It has actually been filed on 18/12/2025, my lord, in the month of November, and issue notice on this IA to defendants through court and speed post, my lord. Already the defendants have been placed ex parte in this matter, my
Where do you
lord.
get that?
My lords,
Where do you get that order that they were set ex parte? How many defendants are there?
my lord, totally 5 defendants are there, my lords.
Defendant number 1 is placed ex parte.
No, my lords, 2 to 5 have been placed ex
Where is
parte.
that order? Please show it.
Page number 41, my lords. The interim order is extended until the next date of hearing. There is an office endorsement.
2 to 5 called out and they are placed ex parte.
Yes, my lord.
Defendant number 1 called out absent.
For defendant number 1, we had filed an application for substitute service, my lords, which came to be allowed, my lords. And now all the defendants have been placed ex parte. Despite having them being placed ex parte, my lords, again the learned trial court has ordered for issuance of notice on IA, my lords.
Please come. The present petition is filed, questioning an order passed, questioning an order dated 3/6/2026, whereby the court has directed issuance of notice to defendants on I number 2. When counsel appearing for the petitioner submits that by order dated 28/1/2026 and by order dated 29/4/2026.
26, my lords.
The other is 29/4/2026.
Apologies, my lords.
Both defendant number 2 to 5 and defendant number 1 were placed ex parte by respectively. It is submitted that when an ad interim injunction is granted and the petitioners file an application seeking police protection, the court has again ordered notice to the respondent. It is submitted that when already they were set ex parte, question of issuing the notice to defendants not arrived. Considering the submission of this court has perused the order sheet. From the order sheet, it appears that the court has placed them ex parte by order stated 29/4/2026 and also by order dated 28/1/2026. In that view of the matter, the order dated 3/6/2026 is set aside, and the trial court is directed to the petition disposed of, directing the trial court to consider I number 2 on its merits.
Please.
Number 44. Ignore Vishwanatha petitioner.
Yes.
Interim order is complied, madam. Deposited as condition amount of 2 lakhs, madam. Memo also and deposited receipts.
This is matter on 110(7). If the amount is not paid by that date, you have deposited 2 lakhs.
Yes, madam. That day 9/7.
Where is the receipt?
Receipt I filed, madam.
Get it?
In the office.
Okay, let's put up.
I have the office copy.
He has a copy.
I have the office copy.
What happened to the notices? Notice is ordered. To the
Steps
interim
is
order.
taken, madam.
Order sheet.
Permission.
Have you taken out hand summons?
And summons take the summons and intimated to the trial court advocate, madam. So he furnishes the court for depositing that amount. Even advance the matter.
That you please do it. It is submitted that as per the order passed by this court dated 3/7/2026, petitioner has deposited an amount of rupees 2 lakh before the trial court.
Yes, madam.
Before the trial court, the respondents are at liberty to withdraw the said amount. This court has directed the petitioner to take out hand summons. It is submitted that they are due to oversight, it would not take the same. The petitioner shall.
We have also furnished, madam.
No, but take out hand summons. Petitioner shall take out hand summons on the counsel appearing for the respondent before the trial and shall file a memo to that effect by 31st of August or else, or by the 3rd of August, or else the stay granted by this court stands vacated. Interim order earlier granted is extended.
45, R.B. Sadashivappa.
No representation list in the month of September.
Cell number 46, preliminary hearing B group.
Lords, 46, I appear for the petition on 46 and 46.1. Lords, both the defendants, the respondents have been served but unrepresented.
This has to be heard finally.
Please, my lords,
We'll hear it tomorrow.
please.
List it in the first list tomorrow. Yes, 47.
Interim orders may be,
Interim order is there.
please.
Interim order earlier granted is extended. List this matter on 5th of August.
Great.
Yes, 47.
Cell number 47.
47, my lord, wherein my lord had filed a previous suit for specific performance, my lord. In that, my lord, categorically stated that I am in position, my lord. Under the agreement of sale, my lord, I was in position. My lord, subsequent, after 1 year from the date of filing the specific performance suit, my lord, the defendant in that suit, my lord, he files a suit for injunction. And my lord, he obtains an order of temporary injunction, my lord. I have challenged that before the in miscellaneous, my lord. That was dismissed, my lord. I am before your lordship, my lord. The
First suit for specific performance. Second is for injunction.
second is for injunction.
In your suit, he is read as
He is arraigned as a defendant. In my suit, he is the defendant.
which defendant?
Defendant number 2.
Defendant number 2.
Please.
In this suit, your defendant number?
I'm the only defendant.
Please come to
And
the
my lord, now my lord, by virtue of this, my lord, he has now filed application before the trial court, my lord, for police protection.
Oh, this is a matter every day.
Please, my lord, please, my lord.
Yes. Please come to the impugned order.
Few facts which are necessary. Dates, 19 to 2021.
I have filed a detailed synopsis, my lord. Separate.
Oh, let me read the order, then both of you can argue. Please come
Because
to the order.
earlier I
Order
have
of the-
purchased, thereafter, I have purchased this suitable property. Thereafter, they have filed the suit for.
No, that is his writ petition. He has to argue.
Yes.
Yes. What is this order of the court?
Though court has not recorded, but the facts remains that on 19 to 2021, I have purchased the suitable property.
19?
19 to 2021.
No. His suit OS number, suit for specific performance,
591 but 21.
591,
But 21. It was filed on 22 to 21.
22,
To 21.
21. And what is the injunction granted by the trial court?
No, in my suit there is no injunction.
You just said so in the.
No, in my suit there is no injunction.
There is no injunction.
After 1 year, my lord, he files a suit for injunction.
Oh, in your suit, there is no interim order.
In my suit there is.
What is your case that you are in possession of the property?
No, in that, my lord, I have sought for specific performance. My first suit is for specific performance. There is an agreement in my favor. I have also produced the agreement before your lord in this writ petition. Even before.
Agreement is there. Is it your case that you are in possession of the property?
Please, I'm in possession of the property. By virtue of the agreement of sale, my lord, I am in possession of the. Without taking that into consideration, my lord, interim injunction has been granted, temporary injunction has been granted.
What is the nature of the property?
It's an agricultural land.
Agriculture land. Now kindly see annexure G, their agreement to sell. On the 100 rupees paper, my lord, they have obtained this agreement to sell. If they have taken possession, my lord, stamp duty and penalty has to be paid as per, my lord, class sale. They are not paid. Only 100 rupees paper on the 100 rupees paper. Apart from that, my lord, sale consideration is also paid. Alleged
You
to be
have filed
having.
the written statement in his suit.
My lord,
You have filed the written statement in his
yes,
suit.
ma'am. Denying everything, my lord. The basis on which they are relying, my lord, possession is not endeavor. They say in the agreement it is stated that earlier you are cultivating, therefore I am agreed to sell the suitable property. There is no delivery of a specific delivery of, my lord, clause mentioned in the agreement to sell. There's only one page agreement where there is no delivery of possession, and they say amount was paid by way of cash. Before, my lord, they have filing of the suit, my lord, I have purchased this suitable property. That is my contention. I have purchased this suitable property.
What, apart from the sale it, what are the other documents that you have placed before?
My
the
lord,
court?
mutation entries. In my name, Kata has been mutated. I have been paying taxes. Kata is standing in my name.
That is all subsequent to filing of this my specific performance. Wherein in that, my lord, the sale deed is under challenge.
Correct, because he has purchased on.
Yes, but no, that is under challenge in my specific performance suit.
2021 is his purchase. Your suit is on 22 to 2021.
No, I am in position, my lord, by virtue of the agreement.
Where are the other, what is the evidence to show? If you're in possession of the property and
No, the agreement itself, my lord, it speaks.
that's the only thing.
No, that's the only.
Yes.
Agreement drawn on 100 rupees paper. First, my objection. And then kindly see, my lord, in the agreement, stamp duty 0. Agreementally, class, it is mentioned in the class, and it is drawn on 100 rupees. Apart from that, they say the agreement is of the year 2018. From 18 to, if at all he was ready and willing to perform his part of contract, what he was doing up to 2020-21. After, my lord, when they have sold
My suit is in time, my lord.
Let him complete.
When they have sold this scheduled property in my favor, my lord, then, my lord, he suddenly wake up, my lord, and filed the present suit. My lord. Therefore, my lord, the court has rightly come to the conclusion that on the basis of registered document, I am in possession of this.
When I was hearing his arguments, I heard that there was an injunction in a
No.
suit for specific
No,
performance.
my lord. No.
Yes.
My lord, by virtue of this agreement of sale, my lord, I am in position. The recitals are in, my lord, are very clear. My lord, now, my lord, by virtue of this temporary injunction, my lord, they have filed an application seeking for police protection to dispossess me.
What did they say in this application?
My lord, I've got a copy of this.
You that?
My lord.
There are two copies, I think. Give him one copy.
Application and I think affidavit. Application and affidavit. It's in Kannada. Therefore, my lord, I'll read and tell. My lord, in view of injunction granted in my favor and confirmed by both the courts, I am entitled to, my lord, take the police protection.
When was this order passed for the appellate court?
My lord, appellate.
18th December 2025.
Yes, my lord.
When did you question this?
My lord, they have filed this application, my lord, for police protection, my lord.
Then only they filed.
No, this order you have kept quiet till 22/6/2026 because there is no limitation.
My lord, all are agriculturists, my lord.
Agriculturists for everything. Don't
In
tell
a
that.
remote village, my lord, Mandya, my lord.
I'm not convinced. If you want, I can hear and pass orders. I'm not inclined to grant interim order. If you want, I can pass final orders.
My lord, at least, my lord, let there be a direction to the trial court, my lord, to dispose of the suit.
No, it is not like that. Because you have come to the High Court, I have to give some order or the other. Yes. What is to be done? Dismissed?
Yeah, no, your lordship will kindly have this matter tomorrow, my lord.
No, tomorrow.
No, tomorrow.
I am convinced to dismiss. So no point of hearing again.
Tomorrow,
Only
my
thing
lord.
is
I'll take,
no,
I'll take instructions and trials. Tomorrow, my lord. Tomorrow, my lord.
tomorrow for what?
Tomorrow I'll
For
submit.
all.
I'll take instructions and.
List it on the top of the list. Tomorrow I'll pass orders. I'm
Please,
going to dismiss it.
please.
If you want to withdraw, withdraw. Yes.
Okay.
What you do? How many matters are coming?
Let's. My lords, one submission, my lords.
With my lords, kindly, my lords.
Madam. Sir.
Thanks. Thank you.
Five.
Is the fate of the advocates greatly.
Madam.
Madam, serial number 8.
Madam, serial number 5, madam. ಮುಂದೆ ಕರೀತೀರಾ ಮೇಡಮ್?
ಹೇಳಿ ಸರ್.
Madam, serial number 8, madam. Madam, serial number 8.
List number 2, all the matters will go dates wherever the urgency where the trial court case is shut down for tomorrow. Then such matters only the date is given tomorrow. In all other matters with the date will assigned in August as per the roster.
Madam,
extend ಆಗುತ್ತೆ.
serial number 14 interim order extension ಗಿದೆ ಅದು. Serial number 14 second list interim order extension ಗಿದೆ ಅದು.
ಯಾವತ್ತಿಗೆ?
ಅಲ್ಲ ನೀವು ಮೂವ್ ಮಾಡಿದೆ extension
ಇದೆ.
ಎಲ್ಲಿ?
ಅದೇ ನೀವು ಡೇಟ್ ಹೇಳಿ ಅದಕ್ಕಿಂತ ಒನ್ ಡೇ ಬಿಫೋರ್ ಅದನ್ನೇ ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದ್ದು ವೇರ್ ದ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ವೇರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಈ ಶಟ್ ಡೌನ್ ಫಾರ್ ಜಡ್ಮೆಂಟ್ಸ್ ಆ ತರ ಕೇಸ್ ಇರೋದ್ ಮಾತ್ರನೇ ಪ್ರೀವಿಯಸ್ ಡೇ ಒನ್ ಡೇ ಡೇಟ್ ಅಷ್ಟೇ. ಇನ್ನು ಉಳಿದಿದ್ದೆಲ್ಲ ನಾನು ಆಗಸ್ಟ್ ಹೋಗುತ್ತೆ.
ಆಯ್ತು ಕುಡಿ ಮಂಡ್ಯ ಕುಡಿ. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 3
ಯಾವತ್ತಿಗಿದೆ ಸರ್ ಜಡ್ಮೆಂಟ್ ನಿಮ್ದು?
ಯಾವತ್ತಿದೆ ಅವ್ರು ಯಾರು ಅದರ್ ಸೈಡ್ ಇದ್ರು
ಹೇಳ್ಬೇಕದು. ನೀವು ಮೆಮೊ ಬರ್ಕೊಡ್ಬೇಕು ನೋಡಿ ಇಲ್ಲಿ ಈ ತರ ಇಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಇವಾಗ ಈ ತರ ಮೆಮೋಸ್ ಬರ್ಕೊಟ್ರೆ ವಿ ವಿಲ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್. ಅದಕ್ಕೆ ಅಲ್ಲಿ ಕರ್ದಿದೆ ಅದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಈ ತರ ಇದೆ. ನೀವು ಜಡ್ಮೆಂಟ್ ಟುಮಾರೋ ಇದೆ ಅಂತ ಅವ್ರು ಬರ್ಕೊಟ್ಟವ್ರೆ ಇದನ್ನ ನಾಳೆಗೆ.
Fifth matter any date.
ಯಾವ್ದು ಸರ್?
Serial number 7. ಅವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಂದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ ಸರ್. ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
7
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೋಡಿ ಸ್ಟೇ ಇದೆ. ಅದರ್ ಸೈಡ್ ಅಲ್ಲಿ ಸ್ಟೇ ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಅಲ್ಲಿ ನಾನು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಬಹುದು. ಅದೇ ಕಾರಣ ಅಷ್ಟೇ. ಅದಕ್ಕೆ ನಾನು ಮೂವ್ ಮಾಡ್ಕೊಂಡಿದ್ದು.
ಈಗ ಇದು ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ ಸರ್ ಎಲ್ಲ No. Wherever the interim orders are there, it will continue till next date of hearing and date will be assigned in the month of August. Wherever your case is set down for judgment or any urgency before the trial court, ಅದನ್ನ ನೀವು ಈ ತರ ಮೆಮೊ ಬರ್ಕೊಡಿ. ಮೆಮೊ ಬರ್ಕೊಟ್ರೆ ಅದೇ ಪ್ರೀವಿಯಸ್ ಒನ್ ಡೇಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕೊಡ್ತೀವಿ.
ಮೆಮೊ ಹಾಕಿ ಇವತ್ತು ಹಾಕಿದ್ದೀರಾ? ಮೆಮೊ ಹಾಕಿ ಇವತ್ತು ಹಾಕಿದ್ದೀರಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದು ಕೊಡಲ್ವಾ ಡೇಟ್?
ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮಗೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್, 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 Court officer? Court officer? Court officer? Court officer? ಕೃಷ್ಣ ನೀವು ಹೈಕೋರ್ಟ್ ಬಿಟ್ಬಿಟ್ರಾ? ಅಯ್ಯೋ 19 ಹತ್ರ ಒಂದ್ ನಿಮಿಷ ಹೋಗ್ಬೇಕಾಯ್ತಲ್ಲ, ಮ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಸಾರಿ 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 ಸಾರಿ, ಪರವಾಗಿಲ್ಲ ಪರವಾಗಿಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್? 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 ಕೋರ್ಟ್ ಆಫೀಸರ್?